lordship, I need to mention for withdrawal two matters, my lord, tomorrow.
Yes.
Okay.
Listing the matter, motion matter, day after tomorrow.
What urgency, have you filed or not?
Yes, I have filed on 28. Last.
Maybe lordship, I beg to mention item number 11. My lord, matter become infractional. I will be allowed to just inform the other service.
3D Gogoi Learned Counsel for the petitioner has submitted that by flux of time, the matter has become infructuous. Also heard Sri R. Gogoi Learned Standing Counsel Forest and Sri N. Das Learned State Counsel Para. With petition is accordingly dismissed as infructuous. Interim dating.
May I please, Your Lordship? With the consent of the other side, I beg to mention item number 12, my lord.
Yes.
Kindly adjourn the day for and I fix it after 1 week, after 1 week.
Lordship, I'm for the petitioner's lordship. The petitioner is terminally ill, lordship. I'm praying for fixed date, my lord, in this matter.
You are for the respondent.
Respondent, 1 to 3 Reserve Bank of India.
Please tell us the date of your convenience. We will try to fix it.
Next week, my lord.
Where are you seeking adjournment, madam?
Mr. P. Hazarika is not available in today, my lord.
Okay.
I'm appearing.
A request has been made on behalf of Sri P.
Mr.
Hazarika Learned Counsel for the respondent numbers 1, 2, and 3. Para. Your name?
Why would we, your lordship, on behalf of Mr. H. Gupta?
On behalf of Mr.
H. Gupta, lordship.
However, the Learned Counsel for the petitioners have expressed some urgency. Para. In view of the above, while the matter is adjourned, the same is directed to be listed on
14th, lordship.
14th is okay? Yes, 14th. 14th, madam.
Obviously.
Much obliged.
May I please, Your Lordship? Lordship, I beg to mention for listing of a writ petition. It relates to eviction,
New matter.
new matter,
Yes, when do you want?
tomorrow.
Tomorrow. Okay.
May I please, Your Lordship, with the consent of the other side, I beg to mention item number 7, Lordship.
Yes.
The engaged counsel is not well, Lordship.
Who is the engaged counsel?
Mr. M. Sharma. It's a minor operation is going to be done, Lordship, today.
Okay, 16 matter. Okay, some
Yes.
personal difficulty. Have you informed the other side?
Yes, Lordship.
Okay. A request has been made, a request for adjournment has been made on behalf of Sri M. Sharma Learned Counsel for the respondent bank, who is said to be who is said to have some medical urgency. Para. In view of the personal problem of the Learned Counsel, matter is adjourned to be listed when? After a week?
Yes.
After a week.
Much obliged.
Yes. Yes, 14.
My lord, first of all, the correction part, my lord, that is in the miscase.
Let will allow. Yes, let us allow the miscase first. Part 3 J. Abedin, Learned Counsel for the applicant petitioner, who by means of this application has prayed for a
Correct.
correction to be made in paragraph 6, in the connected writ petition. First up, it has been submitted that while describing the respondents, the district Dhubri has inadvertently been typed out, in which should be Gwalpara.
Not district, my lord. Deputy Commissioner,
No, district Dhubri,
district was correct.
then
The Deputy Commissioner Gwalpara should have was made Deputy Commissioner Dugri. That is page
that is we have said,
uh,
it should be made to Gwalpara now.
Gwalpara.
Yes, yes, that is what we have said. Oh, you have taken a chance to correct others also.
District Commissioner.
Date was also wrong.
One particular date was, my lord. I made the all the
The
three.
liberty was only for the district. You took the chance.
Yes, my lord.
He has also pointed out that in paragraph 6, a date has been written as 17/3/2025, which should be 17/6/2025. And further, in prayer two, the annexure, instead of annexure 5, annexure 2 should have been written, full
Yes.
stop para. After hearing the learned counsel, comma, the aforesaid three corrections are allowed to be done, full stop. The learned counsel is accordingly required. The IA accordingly stands allowed, directing, permitting the learned counsel to file an amended, a corrected writ petition. Full stop. You take the writ petition, huh? We take it for motion now,
Yes, madam.
but make the corrections, okay?
Okay, madam. My lord, your lordship will come to page 25, annexure 2.
What is the subject matter?
My lord, this person was totally not authorized to take up the hearing and pass the impugned order
Regarding?
regarding disqualification. Under, if we take.
Yes, PNRD. Madam Thapa.
My lord, if your lordship remembers that day, your lordship was about to pass the interim order. At that time, this annexure.
How do you know that the interim order was about to be passed
My lord,
and not about to be rejected?
reading
It is about to be rejected.
reading the mind of the court, my lord.
You cannot read the mind of the court. Difficult, most difficult task.
Yes, my lord, yes.
But as though there
We
is-
dismiss a writ petition with a smile.
Normally, that smile is also seen, my lord.
Yes, madam?
Lordship, as Mr. Azota is on legs, Lordship, in court number 1. For the
It-
time being, Lordship.
Ask him to come.
Lordship,
I will not let you repetition to officer. Wait, after a while. Yes.
Lordship,
Yes.
Lordship may take up this matter after some time as Mr. A.R. Goya is on leg in court number 1.
What is the matter?
The matter relates to eviction.
Again, same order.
Same order, my lord. Lordship has.
We'll pass the same order,
Unread
madam.
The order, Lordship, pass the order. Madam.
7th was the date. Now today we are on 5th.
Yeah.
What time will remain now?
The notice.
Date of the
Notice is-
notice is same.
Same,
Then why did you come late?
24/7/25 is the date.
I hardly will make any. What relief are you expecting to give to the client? 2 days relief. Will not help. And we're not going to extend,
Lordship,
because if had it been a notice of a later date, maybe 7 more days.
more.
Notice is of the
That's-
same date.
Same day.
If you want your senior to be here, because we are not going to pass any other order,
Lordship,
let him come.
madam.
কোনটো তবে কোর্টে কি আছে নি আহিছে নেকি মিস্টার চৌধুরী instructions are there? Yes, Soni? Yes.
Lordship,
Have you taken instructions on?
Yes, my lord. But Lordship may for a moment turn over to page 8 where their prayer is only for release of the goods. They have not assailed the proceeding. And if Lordship allows, then section 129(1) read with rule 140. Those section and rule prescribe the procedure of releasing the goods.
Let us see. Which you're referring to GST rules?
Yes, it's permitted to, they have initiated the process, proceeding under AGST, but it's permitted to the CGS.
159.
Lordship may first take up section 129.
Yes, please.
Lordship, subsection 1, notwithstanding anything contained in this act, where any person transports any goods or stores any goods while they are in transit in contravention of the provision of this act or the rules made thereunder, all such goods and conveyance used as a means of transport for carrying the said goods and documents relating to such goods and conveyance shall be liable to detention or seizure, and after detention or seizure shall be released. Lordship, ABC, they prescribe the procedure, and with regard to the issuance of bond and Lordship, Rule 140.
Bond.
Yes, ma'am. Bond and security for release of seized goods. The seized goods may be released on a provisional basis upon execution of a bond for the value of the goods in form GST in 0.
Yes, Mr. Soni,
We are ready to give bond of value of the goods, your lordship.
but the 140 has to be correlated. Rule 140 has to be.
But here what happened, your lordship may see. Our specific contention is that they have only issue MOV2. We immediately appear before this honorable court.
No, we are not going to the merits of the case. We are only on the aspect of your submissions that the goods are perishable in nature.
Please, your lordship.
On that aspect, we are trying to make a consideration.
Please, your lordship.
Now, there is a procedure prescribed both in the act and the rules that if a party is willing to furnish a bond, the bond would be of what nature? But the entire thing has been prescribed in Rule 140,
Please.
which has to be, it cannot be read in isolation. It has to be read with 129 of the Act, Section 129. Section 129 has laid down what is to be paid. Now, if you want to make some submission, you can make that.
Even
Digressing this, in spite of this, you want to make something else. Will it be possible?
even here, your lordship, in this case, their first submission while first hearing that there is a discrepancy of only quantity. Therefore, this matter was kept to verify whether it is 15,000 quantity or 25,000. Even there is no dispute regarding.
Mr. Soni, you are not getting what we are not on the merits. You may have a very good case. We are on the aspect of releasing the goods by furnishing of a bond. Now, the bond will be in what nature? How do you correlate this?
But-
See, the bond has said that of furnishing of a security in the form of a bank guarantee equivalent to the amount of applicable tax, interest and penalty payable. If you go to a tax, interest and penalty payable, it will be a huge amount.
Huge amount.
What do you say on that?
And even
What amount of bank guarantee are you willing to furnish?
even as on today, your lordship may see. My lord may see my bill. Page 22.
Page 22.
Please, your lordship. It's tobacco leaves. Its rate is 30 per kg.
Hmm.
Total amount with tax is 4,72,500.
Hmm. Yes.
I'm ready to give the bank guarantee as well as bond of this amount, your lordship. Subject to final outcome of this petition or subject to raise all the objection regarding the merits of the case, your lordship.
Lordship, if he wants to give this amount, Lordship, it will be contravening the section and the rule, act and the rules, Lord.
Hmm.
But this detention, seizure, is the subject matter of adjudication.
Yes, ma'am.
He is challenging the legality. Now, if he fails, then the question of payment of the amount under 129 may arise. Now, we are thinking, considering an aspect that before the issue is adjudicated, how to strike a balance, because the goods are perishable in nature. Had it been any other goods, then the question of him paying, paying only the amount involved would not have arisen in view of 129. 129 says that amount equal to 2% of the value of that of 25 cents and payment of
Lordship,
penalty equal to 200%
yes, ma'am.
of the tax of such goods.
Lordship, may kindly turn over to page 6, where in paragraph 7.
But no, see, Mr. Chaudhary, let us read again carefully. 129A, what is the amount of the payment?
On payment of penalty
Equal to 200% of the tax
tax
payable.
payable.
What is the tax in this case? Have you tentatively ascertained the tax?
Lordship, here taking into account every aspect, Lordship, the tentative amount is in page 86. It will come around 23 lakhs something. Lordship.
Tax?
In all total.
What would be the amount of
tax-
tax? Or,
Tax
okay.
will be, Lordship,
23 lakhs.
no, in all total. Lordship. Tax will be about 3 lakh 30 something, Lordship.
3 lakh 30.
And thereafter penalty will be there. Cess will be there.
Penalty.
In all total, it will be 23 lakh something. Lordship.
He is willing to give a bank guarantee of the total amount, 4,72,500.
Lordship, if Lordship takes into account the page 22, the amount of tax he has paid, it is about 22,500. If we take into account the section 200%, it's less than 200%. It will. No. But in paragraphs,
It will not be 200.
No,
Is it
Lordship.
200%.
but
It's
in
22,000. He is willing
Yes.
to deposit a bank guarantee of 472, the value of
But
the.
in Lordship, paragraph 7 of the repetition, he has stated that he is willing to pay that tax.
But it is all
In
to-
paragraph 7, Lordship, he has stated the tax and the petition states that the petitioner is ready and willing to pay the tax
So
amount
what-
levied by the authority.
What is the tax amount?
Lordship, it will be 300 something.
Huh?
300 something.
Tax amount.
300 something. Lordship, because it will include CGST and state
300
GST.
something means how much? 300 what?
Lordship. Lordship, it will be 3 lakhs 36,000. And thereafter, Lordship, cess will be included at the rate of 56%. It will come to 6 lakhs 72,000. Then penalty will of 200%. After the tax, Lordship, CGST penalty, state GST penalty, and cess penalty. In all total, it will come to 23 lakhs 52,000 only.
Even my lord, with due respect, they are not clear. Because my goods are unmanufactured tobacco, no cess will be applicable to them. Even my lord may see that.
Lordship, those
calculation.
things he will have to prove, and if
No,
required, Lordship, there is alternative remedy.
No, those aspects we are not even going to. We are only on the aspect that whether how can we consider the aspect of release of the goods, which is submitting to be perishable in nature. How do you safeguard your interest, the interest of the revenue? That is what we are trying to.
Even as per their calculation, Your Worship, 3,36,000 is GST state tax as well as central tax, 3,36,000. Even today itself, I am ready to pay 4,70,000 more amount, Your Lordship, subject to reserving my all right.
He is willing to make this amount a deposit of 472,500. What is which is the value of the goods?
I leave it to your lordship then, because
No, no,
under
if-
the.
No, if, Mr. Chaudhary, you are correct, you have correctly referred to the provisions of law which would come into operation in this kind of matter, but we are considering at an interim stage. You take instructions that he is going to this 472,500, which is not strictly in accordance with 129. It's only would be a measure to balance the interest of both the parties. Okay, we'll have it when.
Lordship, after 10-15 minutes,
Okay.
I can have.
Even recently, considering the nature of the dispute, this honorable court has also released the goods on the basis of the bond, your lordship. Shall-
Okay, you show it to your friend. Okay, after a while. কোনটো আছিলে? Yes, Mr. Doctor,
My lord.
we have allowed the IA,
My lord.
allowing him certain corrections in the writ petition. Now he says that this order has been issued by a person without authority of law. What do
Yes.
you, what is your?
I have gone through the order, my lord, but this order is saying, my lord, that liable to be disqualified. He didn't directly disqualify the petitioner, my lord.
Let us see,
Lordship, my kindly page number 28.
28.
Yes, Annex 5.
Is it,
Last paragraph, my lord.
yes, sir.
Is liable to be disqualified under 111F of unsaid
Yes,
Sampanchayat Act.
he's trying to take out something out of
But
this sleeve.
disqualified. But disqualified. Earlier paragraph. Means liable to be disqualified him. That's all.
No, my lord. Disqualification and liable to be disqualified is different, my lord.
It's okay. Then he says that I'm not disqualified. I've yet to be disqualified. It's okay. Then the purpose is, then case may be disposed of in that line, my lord.
My lord, I'm saying what I'm submitting is
More
after
than-
this,
I'm more than saved.
just one order from district commissioner is sufficient, my lord.
Now, is there any order from the district
That
commissioner?
I don't know, my
No,
lord.
no,
Like I
nothing.
said, my colleague can take instruction, my lord.
My lord, only thing is that your lordship may come to page 25, Annex 2.
Well, let it be after 1 week. I'll be in the,
Hmm?
let it come after 1 week. In the meantime, I'll be in the instruction regarding the order passed in page number 28, Annex 5, my lord.
Why 1 week?
My lord, before that, I'll just bring.
Today, let it be on Friday, my lord. Today is.
Okay, you,
It's okay, but would your lordship be pleased to see page 20?
now we'll indicate your thing. Heard Sri J. Abedin, learned counsel for the petitioner. Petitioner is, who is aggrieved by an order dated 5/8/5/7/2025, whereby issued by the District Development Commissioner, Gwalpara,
My lord, in fact, two orders are there. Annex 2 is also a challenge.
Commissioner, whereby the petitioner, whereby it has been stated that the petitioner is liable to be disqualified under certain provisions of the Assam Panchayat Election Act 1994. The petitioner has also made a challenge to the communication dated 13/6/2025 issued by the said authority on the aspect of a hearing on a complaint lodged against the petitioner regarding his election. The competency and powers of the authority is the specific ground of challenge. Full stop, para. It may be mentioned that regarding certain errors which according to the learned counsel had inadvertently crept in, IA 2496/2025 was filed, which has been allowed today. Full stop. The learned counsel has also been directed to file amended writ petition. Full stop, para. Sri Doctor, the learned Standing Council, PNRD, has however submitted that the order dated 5/8/2025 does not appear to be the final order, as the expression used is, within inverted comma, liable to be disqualified. Full stop. He, however, is not equipped with any further instructions of the district commissioner passing any subsequent order. Para? Sri, and thus, London State Council submits that some time may be granted to him to enable him to obtain instructions in this regard. Para? The prayers appear to be reasonable. Full stop. Though pre-emphasize, the district development commissioner would not be the authority to pass an order of disqualification, comma, on the prayer made by the learned counsel for the respondents. The matter is adjourned to be listed on
Friday, my lord.
Friday.
I will not be available, but he will.
Friday, then let it be on Monday, my lord. Monday.
I have no issue. Now I'm not disqualified, you said.
On Monday?
Monday.
On Monday. In the meantime, the petitioner would file the amended writ petition with the corrections
I'll file
and
it tomorrow,
serve,
my lord.
and serve copies of the same to the learned counsel for the respondents.
Extra copy of the JD.
Ajay no, kali-
5 July.
5 July.
5 July we have said.
5 July.
Yeah, your lordship.
Second time 5/8.
5/8, no, 5/7.
5/7.
My lord, the instruction is in regard to only annexure 5.
The hearing, more than the hearing, whether he can call for the
Yes,
hearing is different, but whether the
He has
final
been
order of disqualification, who has passed? Is there any subsequent order
Yes,
passed by the district commissioner? Yes, next.
Obliged. Deeply obliged, ma'am.
Hmm.
Amended writ petition, Gaurapura banaya nahi bolega.
15,
May I please this your lordship? Lordship, I have taken instruction from learned counsel, Mr. A.R. Goya. Lordship may pass the similar order.
you have a copy?
Can be taken after some time, Lordship.
A similar order we are passing till tomorrow, day after tomorrow.
Yeah.
No, till 7th. 7, you have a copy of the order, madam?
Yes.
It is annexed in the petition, my lord.
Which page?
Page number.
You don't know.
No.
You have to search in the court. Where is your note?
It's in 200.
It's 200. Okay. 200. No, it's not the case. Is it this case? Forest?
Yes.
Is it forest area?
Forest.
Then this is not the order.
Like, can it be after some time, my lord?
Madam, this is
He-
not the order. This is the order where there was a confusion or there was no distinction between the revenue land and the forest land.
19.
What is your case you're trying to project now?
It concerns the same reserve forest. South
Which-
number,
Huh?
south number reserve forest.
Perhaps this is not the order which will be applicable.
199.
199.
Order.
Yes, 199 would be the order. You're correct.
Para 8, my lord, is
199, yes. And what is your name, madam?
S. Losco.
S. Loskar. S. Loskar, huh? Yes, Mr. Bhabujari, 199 page order, not 200, 185 order. There are two orders annexed to the writ petition.
Right.
That's 7 days time.
Yes, 7 days time. Yes.
No, not the 185. 185 was not demarcation.
No.
199. Okay, S. Laskar and R. Pujari. And who else? Forest. Forest, I bought Thakur, huh? I said, how many of you are there, madam?
Petitioner.
This way, kitna number? 200 है ना?
60 petitioner.
Last में करा दीजिए, मैं कर लूँ. Okay.
Similarly situated with that of
Then-
minor
then-
order, yes, minor.
No, had the notice been of subsequent date, then we had have given 7 days extra. Now notice is of the same date. We are not,
Yes,
we will maintain the same order.
minor.
Okay,
I'm so grateful, man.
next. Assam State Finance Corporation. 2015 matter,
Yes, Lordship.
1 decade.
Yes, Lordship.
Yes, please.
May I appeal, Lordship? In this case, Lordship, in 1987, the petitioner approached AFC for providing a minibus on a hire purchase basis. Then
Providing loan for purchasing a minibus.
that time he approached for on hire purchase basis, providing a loan.
Loan
Yes.
only, they'll not provide a bus.
Bus, Lordship, not loan.
Bus.
Yes, Lordship.
They applied for loan matter, not
No.
hire purchase. We denied.
I will show all.
No,
the-
no, no.
Yes.
We are not on hire purchase we are on the saying that AFC will not give you a bus. It's a financial corporation. They'll
Yes,
prov-
Lordship, that is
They'll,
that.
they'll provide you the facility to get a bus either for hire purchase or whatever is the arrangement, we do not know. But they'll only provide you the finance.
For finance.
Finance, yes.
Yes, Lordship. Then they insisted him to purchase a second-hand bus, minibus. That was one person, he has defaulted. That is why they insisted them to purchase that bus. And amount was 1,60,000 at that time. They had taken all the documents from the petitioners, signing on some blank papers and other, as per nowadays, Lordship know about that the financial institution, they have taken every papers from the petitioners. Well, but they did not fail to provide that bus to the petitioner.
Bus was not given.
Not given. They had not sanctioned any loan, nothing else. They subsequently in 1993,
The amount was given to you or not?
no Lordship,
No amount given.
no amount. Then Lordship, they the
Bus also not given.
no Lordship. Kindly turn to then Lordship, they approached the filed a Bakijai proceeding before the Deputy Commissioner Kamru in the year 1993.
Akijai proceeding instituted against you.
Yes, Lordship. Kindly turn to page 23, Annex 4.
Page 23.
Yes, Lordship. On the writ petition,
Yes.
Annex 4. Order dated 27/1/99.
Order dated 5/2. Oh, okay, 27 one.
27.
Yes.
That was communication of
Yes, yes, yes.
Heard learned counsel appeared on behalf of the debtor and decree holder. Another side, Mr. Ratul Molla Bujorbura. He was the owner of that bus. On his or his advocate neither present in 19/1/99 or 27/1/99, nor took any steps or submitted any documents. I have heard the contentions of the debtors. The contention of the debtor of the AFC purchase of the AFC purchased a minibus bearing number AMK 3005 on hire purchase agreement with AFC, and accordingly required documents were prepared on entered into a hire purchase agreement with the Ratul Molla Bujor Borkwa. But taking advantage of his
This
innocence.
is in your favor.
Yes,
This order is in your favor.
yes, that the Bakijai proceeding was dismissed.
Rejected, yes.
And on the basis of that, no, that minibus has been handed over, was handed over to him.
Yes.
That is why entire order
Then why are you aggrieved?
agreed subsequently after 9 years of that proceeding, they again issued a notice under section 29 of FC Act to for taking possession of the property which was mortgaged before the AFC.
Where is it? Page?
Lordship, I-
Date?
That is, I have not annexed, probably last, last annexure I have. Lordship, in that case, that earlier the petitioner has approached this before this honorable court. And that was disposed by with a direction, Lordship. That is page 35 annexure 7. But on that day, the counsel for the petitioner was not present in the court, Lordship. And petitioner was not aware of the passing of the order on 11/11/14, Lordship.
What has happened thereafter? Did you,
Yes, Lordship.
was there any settlement reached?
He had not no knowledge about that disposal of the case because his counsel did not inform him. Subsequently, we had received another notice from one 19/3/15. That is annexure 8, Lordship,
Page?
page 39. That is 19/3/15, Lordship.
Yes.
Whereby directed to one Umesh Goswami to submit the valuation report. After that, the petitioner again filed this writ petition, Lordship. And that Bakijai proceeding was Bakija proceeding was that initiated by the AFC that was dismissed in the year 1999 after more than 18 years. Whether these they have again sent notice to take possession of my property. That is joint family property lordship. That was they have stated about the mortgage of the property. Regarding mortgage also, that is not in accordance with law. And whether the petitioner is a your lordship, whether industrial concern to give the provide a minibus. They mentioned about the loan. I have never took any loan, and this is my contention before this only. I have never took, they have not provided any loan to me, and they have not handed over the minibus to the petitioners. That is, as per the State Financial Corporation Act 1951, what is the industrial concern, Lord? I'm not an individual cannot be an industrial concern, Lordship, as per provision of the Act.
Yes,
Yes, Lordship, that is page 29, annexure 5 is the notice under section 29.
29.
Yes, Lord. This is the notice issued by the AFC on 19/7/2008.
29.
Yes, Lordship.
No, present notice is at page 39. 19.3 you have said.
29 in present 39,
39.
and that is main notice under section 29. That is only the by this on 2015, one valuer was directed to submit a valuation report of the whether after lordship, if it is a mortgage property also, I'm not admitting that, but if it is a mortgage property, then also they cannot issue notice after 12 years. They have stated that I have taken loan in the year 1987. And Bakija proceeding was initiated by them, also dismissed on 1999, Lordship.
Where is 87 he written here?
They have mentioned that I have taken loan.
Please come to page 29.
Yeah, they have not mentioned anything. They have not mentioned. Indeed, that Bakija proceeding, it is mentioned, stated everything, Lordship. That is why I wanted to show that.
Yes.
Well, that is why, at least see that annexure 4, the Bakijai proceeding, where it is stated, Lordship. May I read from the first?
Which page, madam?
Page 23, that is the Bakijai proceeding.
23.
Yes, annexure 4.
This we have read. This you have already read.
But here it is specifically mentioned that the vehicle was not handed over to the petitioner at any point of time. And they have not provided any loan.
Yes.
Second paragraph of 24, Lordship. I have examined the letter of Secretary of the Regional Transport Authority dated 27/6/94 by so and so, a letter of the Transport Secretary dated 19/8/94. But accordingly, those letter, the vehicle bearing AMK 3005 stand in the name of Ratul Molla Bujor Burwa up to 19/8/94, Lordship. Prior to that Bakijai proceeding. Ownership of the said vehicle has not been transferred in the name of Ratna Goswami, that is the petitioner. Accordingly to the letter of the Secretary to State Government, State Transport Authority, Assam, by letter number so and so, letter number MK 3005 under HPA between AFC and Ratna Goswami, hire purchase agreement between the Ratna Goswami. But said Sri Ratul Molla Bujor Bora did not apply to transfer the ownership up to 19/8/94. The regional manager AFC Assam by letter dated 16/6/93 by letter number so and so has submitted 2 demand forms. I have observed that the amount shown in the said letter and the said demand form are not the same, and decree holder has failed to establish his case under section 44(2) of the Bengal Public Demand Recovery Act 1913 beyond a reasonable doubt. It is a matter of very grief and anguish that the FC has failed to submit all such required information, accounts and documents accurately to establish a person to be a defaulter. Anyway, under considering all the information, documents and arguments on both the side's lawyer, I am convinced that a person cannot be treated as a debtor without making an application for a loan. It is totally perverse in law in convert the private hire purchase agreement loan of Mr. Ratul Molla Bujor Bora into name of Sri Ratna Goswami. It has been established that though the demand form was submitted on 16/6/93, in the name of Ratna Goswami, but the ownership of the vehicle was stood in the name of Ratul Molla Bujor Bora up to 19/8/84. At last, the amount of loan shown in the letter in the demand form of the decree holder is not correct and true. See, so the Bakijai proceeding demands form initiated against Ratna Goswami, son of Bhubaneswar Goswami, resident of so and so, in district Kamravasam under section 44(2) of Bengal Public Document Recovery Act 1913 is hereby rejected, and the concerned demand forms are also dismissed. This is no vehicle was transferred, Lordship. That is stood in the name of our earlier person, the Ratul Molla Bujor Burwa.
Okay.
In their Lordship, In the affidavit in opposition filed by the FC Lordship.
Hmm.
Page 3, Lordship. Ma-
It's free.
Page 3, paragraph 8, Lordship.
Yes, please.
May I read, Lordship? With reference to the statement made in paragraph 2 of the petition, I must respectfully state that Sri Ratul Molla Bujurpura purchased a minibus bearing a number so and so by taking loan from the respondent corporation, and he was defaulted in making payment of installment to the respondent corporation, and Sri Ratul Molla Bujurpura by letter dated 14/11/84 intimated the respondent corporation that he is unable to run the vehicle and also not able to repay the dues, and he found a buyer, namely Sri Ratna Goswami, who was willing to take our liability of the vehicle.
Yes.
On the same date, that is on 14/11/84, I never went to AFC. My contention, I approached in 1987. 1911/84, Sri Ratna Goswami, petitioner herein, wrote a letter to the respondent corporation that he was interested to purchase the said minibus number so and so, which belonged to Sri Ratul Molla Bujurpura, and he also interested to pay a sum of rupees 10,000 to the respondent corporation, and also interested to give all the necessary documents along with land mortgage. The petitioner also intimated that he was doing timber business with a four-wheeler truck. They have stated that I approached, this contention I denied in my reply, Lordship. I never had approached before the FC in the year 1984. Then Lordship can do page 6, second paragraph, Lordship.
Which one?
Second paragraph, Lordship, page 6.
Please read.
As the land belonging to the father of the petitioner covered by DAG number 663 and 624 of KP Patna number so and so, village Kokijhar, Moja, Sayani, PS Palasbadi in the district of Kamarabi has been mortgaged to the respondent corporation. To the respondent corporation can take over possession of the land, whether that mortgage is a valid mortgage or not. Whether there is a limitation in to recovery or take possession of the mortgage property. This is the main issue, Lordship. After 18 years or 20 years, now it is running 37 years. After dismissal of the Bakijai project, they never approached before the any higher court, Lordship, against that order. They came. They issued notice under section 29 subsequent to that. Later on, after dismissal of the petition in 2008. They have also mentioned that I am the industrial, as per that FC Act also, I am not an industrial concern. An individual cannot be an industrial concern. Moreover,
Yes.
Yes, Lordship, I can come. They also annexed some of the documents which I have denied because there is no signature of the petitioner that his signature was forced. I'll show that. Can we turn to page 231, Nikki? 31
Of the,
of their affidavit in opposition, Lord. First, page 30, Lordship.
yes,
This is written by some other person.
this is Ratul Mollo Buzarbu.
Yes, yes, Ratul Moldo. He has stated that his vehicle in the year 1984. Subsequent to that, the annexure 6, page 31. This is also not my signature. Then Lordship, page 32.
Just a minute, please.
Yes, Lordship.
Yes.
Then page 32, Lordship, annexure 7. That is the letter 26/7/86. I have not signed this. This is not my letter. With due respect, I inform you that Universe now number so and so is already allowed to transfer from Sri Ratul Mollo Bujur Burwa to Sri Ratno Goswami. But I, Lordship, I, Sri Ratno Goswami. What is the necessity? I, Ratno Goswami. Because Ratno had written this letter. I, Ratno Goswami, am so sorry to inform you that this case, this card is unable to me on July 85 due to my serious illness. Now I am abide by your rules and regulation. Therefore, kindly transfer the card to me. It is letter of 1980. There are third person has written this letter, and the signature also I have denied.
Yes.
Page 34, Lordship. Some amounts 1,60,000, 858 up to, they've shown November 90 from July 87. I do not know about that. Then
This is a payment schedule.
yeah, payment schedule, the AFC. I do not know about that payment schedule, Lordship. Page 35, Lordship. Annexure 9. This is the DP note from the side of petitioner, Lordship. That was on 27/8/87, Lordship.
What is this DP note?
DP note they have prepared, I have signed it, Lordship. And but below that page 36, the signature of that is not his signature. On the revenue stamp, the petitioner has had signed. It is a DP note regarding that he is given 41 installment of that for purchase of that minibus. That is on 27/8/87.
Yes.
That annexure 10 also I have written, Lordship. On 3/2/88. Regarding damage condition of the vehicle.
But the vehicle, when, if you go by these communications,
Yes,
it
Lordship.
appears that you had taken possession of the vehicle. And see
Yes.
the dates, the DP note is of August 87
Yes, Lordship.
and the damaged condition of the vehicle was intimated in February 1988.
Yes.
So it implies that after you had taken over possession, the vehicle was damaged.
It is in the name of Ratul Moldo Bujur Burwa. Not in my, till 1994, the vehicle was in the name of Ratul Moldo. I never, they are never transferring, and that is with the AFC. That is why I have informed the AFC.
But this letter at page 38 is on a different aspect. You have almost, maybe on record, the vehicle still stood in the name of the original owner, Ratul
Yes,
Mullah.
yes,
But
Lord.
page 38 shows that you have already taken over possession in August 1987, and thereafter the vehicle had suffered some damage and it was under repair at some motor works at Beltola.
Yes, Lordship. That is in my, in the page 37, Lordship, and actually 10,
Yes.
last line of the first paragraph. And after a few days, it will go to delivery position. There, for some time, he has taken after accident. Then the Ratul Mollo said Ratul Mollo Bujur had forcibly had taken back the vehicle in his custody.
Where is it?
It is in my writ petition, Lord. That is page 4, page 6, paragraph 4, Lordship. Second paragraph, page 7. After executing necessary documents, DFC sat silently and did not hand over the vehicle, that is minibus, as assured, and did show in their documents that loan has been granted to the petitioner to the tune of rupees 1,60,850. Where the fact remains the FC neither had disbursed the cash against the said loan to the petitioner nor handed over the vehicle. The petitioner repeatedly approached the FC for taking possession of the vehicle, but in vain. Finding no other alternative, the petitioner approached Mr. Ratul Mollo Bojurborg and requested him to hand over the vehicle to the petitioner, which he stoutly denied. The petitioner also thereafter somehow took the possession, Lordship, of the vehicle by using force. However, after few days, Ratul Mollo Bujur came to the place of petitioner along with some other person of desperate nature and forcefully obtained the signature of both the petitioner and his blind father on certain documents and threatened with dire consequences and forcibly took away the vehicle with him. The petitioner vehicle verbally informed the AFC about the entire episode, but the AFC did not take any action in this regard and took no steps to recover the possession of the vehicle from Ratul Mollo Bujurbu. Till 1994, the vehicle was in the name of Ratul Mollo Bujurbu till filing of the Pakijai proceeding. And in the Pakijai proceeding, it is from the order, it is clear that the vehicle is in the name of Ratul Mollo Bujurbu, or the original ownership. The FC stand is that they have given loan to me, and I have denied that no loan has been sanctioned. On 1,60,000, they provide for the vehicle, but that vehicle was not provided to the petition. Lordship, kindly turn to page 40, Lordship.
40.
40. Annexure 12.
40 of affidavit.
Or affidavit, Lordship. They have stated that they have sanctioned 1,60,000, Lordship.
One lakh 12,000.
No, they have mentioned that they have given 1,60,000 for the vehicle.
Yes.
Now, Lordship, here 1,12,000. Why they have given notice for 1,20,000? 12,000. That is in my name, Ratna Goswami, 27,887.
Who is Bhubaneswar Goswami?
his father. Now expired lordship. He stood as a guarantor.
Yes.
In there, that note, annexure H, they have mentioned 1,60,858,
Page
page 34.
of the affidavit. Of the
Yes.
affidavit.
And yes, annexure. I'm reading from a affidavit. Annexure H, page 34.
Yes.
Till November 90, it was 1,60,000. And 18,490's notice, they mention about 1,20,000, 12,000 sanctioned loan. All documents have been prepared subsequently, Lordship. And second page 41, that is a part, second page also, they mention 1,09,900, 1,09,900.
Second page of?
That annexure 12, Lordship, page 41. Page 41, Lordship.
1,12,000.
Yes.
Subsequently.
Yes.
I mentioned about 1,60,000 I have taken, I defaulted. But why they have in the year 1990, again, they have stated that 1,09,000 or 900.
Where do you get 1,09,000, madam? Which page?
41, page 41, Lordship. Amounting to rupees, that is typed,
That is 2,07,000.
no, over that is 1,09,000, Lordship. It is written 1,09,990. Page 41, Lordship.
Yes.
That is typed, subsequent typing. And below that with interest 2,07,000. 7,212. If I had, they were provided 1,60,000, I have defaulted, then how it will be the 1,09,900.
Yes.
Annexure 13 also same, Lordship. 14,393. that was also 1,12,000 plus
Page,
page 42.
yes,
Here they have shown 1,80,000 plus interest. 1,87,000 interest.
and this is total demand is 2,88,000.
Total demand is 2,88,000. But after calculating 180 principal amount and 187, yearly interest 1,87,000, 360, it amounts to more than 3 lakhs.
Yes,
That is also prepared subsequent to that. Then 44 is the notice, Lordship. That notice I have challenged. It is issued in 19/7/2008. After 18 years, more than 18 years, Lordship. Is there any no limitation for FC, Lordship?
okay.
And 45, page 45, annexure 15, they have mentioned about a seizure list. 1/8/2088. 2008. Here they have mentioned 1 vigor, 2 quota, 13 lesage of DAG number 624 under patta number 53. But no person has visited their place. They mentioned one Assam type house. There is no Assam type house in the said DAG.
Yes,
Page 46, they have the official present. There is no signature of the from the petitioner side. That is magistrate present, then official present. All the official AFC Lordship.
yes,
Lordship, the father of the petitioner, they have taken signature on some papers and that is them. He stood as a guarantor, Lordship. That was registered. Page 58, Lordship. Annexure 17. That is 7/9/2000, 28, 26/8/87. Deed of guarantee, Lordship, 26 day of August 1980. Sri Bhuvaneshwar Goswami, son of so and so,
yes,
called the guarantor. He is
yes,
not a mortgage or guarantor. He stood as a guarantor. Page 59, Lordship.
Yes.
Can you see the execution is admitted by Sri Bhuvaneshwar Goswami, so and so and so and so. And last part, that is signature of the probably sub-register. The execution is exempted, hereby exempted. Why it is necessary to exempt the signature of Bhuvaneshwar Goswami? He is not a renowned person. Also. They can take a signature and subsequently submit all the papers before the sub-register. Lordship also know about the sub-register office.
Execution is
Functioning.
not exempted, execution is admitted.
Last line.
Where?
It is very small. Second page I will show Lordship.
Yes, second page.
Like, no, not in second page. This is guarantee he has given. He had given. Then they had taken a 60 page 65 and actually 19.
No, no, there's no exemption. Execution
Exemption.
is,
I'll show the,
execution is admitted by Bhuvaneshwar Goswami, son of
Yes.
so and so.
yes.
The LTI of is so and so by
He's exempted.
identified, not exempted.
Lordship, I'll show the exempted in page 69 of the irrevocable power of attorney. Same person.
Is 69 of?
Annexure 20. Page 68, that is the irrevocable power of attorney
Yes.
by the same person. His name has been written subsequently. And page 69, Lordship.
Yes.
Execution is admitted.
Admitted.
LTI of the so and so are exempted. Executed 2 deeds on the same day, 26/87/87. That
Yes.
was also not admitted. That was exempted, are exempted. What is the necessity to exempt the signature of the thumb impression of the, because they were not present on that day. Guarantee was given, but not before the sub-register.
Yes.
In the seizure list, they have mentioned about 1 bigger 3/4 13 less, 2/4 13 lesser of land, annexure 16, page 45. But page 17, Lordship,
17.
70.
70.
Yes, Lordship. In the said irrevocable power of attorney. But that person has already expired in 1988.
Who the father?
Father, because that time he was not well and he was blind, Lordship.
Yes.
Page 17. They have mentioned paying the land measuring about 2 bigger 3/4 8 lesser under DUG number 663, 624. 2 DUGs. In the irrevocable power of attorney dated 26/8/87. And below that, Lordship, that the application stipulated in the loan agreement dated. There is nothing in the loan agreement dated. Why it is blank, Lord? There is no loan agreement.
Okay.
Agreement dated and on the principal creating first mortgage or charge in favor of the corporation over the said properties of the principals measuring 2 kotha 3 2 bighas to 3 kotha 8 lessons situated in Mouja Soyani district so and so, and the building sheds and structures thereon and the machinery therein and first hypothecation of the movable plants and machinery. There is no plants and machinery. There is no agreement for taking loan also. And in the seizure, they have mentioned about 1 bigha 3 kotha 13 lessons, 2 kotha 13 lessons. Here they have mentioned 2 bigha 3 kotha 8 lessons.
Yes.
All those documents I have denied, Lordship. Page 71, paragraph E, Lordship. The corporation has also stipulated that the principal shall for aforesaid purpose execute an undertaking in favor of the corporation and shall simultaneously with an execution of such undertaking grant of irrevocable power of attorney. It is now not inoperative because the person is expired in the year 1988. That is equitable mortgage that was not registered. Page 74. They have given stamp and seal of the sub-register, but that is strike out. Page 74.
Yes.
Annexure 20 to page 76 is deed of hypothecation. That is amount to rupees. They mentioned by taking over the present outstanding liabilities amounting to 1,60,000. In a hypothecation, that deed also, first page I have signed, but subsequent page, all the signature are not my signature, Lordship.
But come to one, the 83 onwards, each of the pages has got your signature. 83 on the original, the photocopy.
No, that is the photocopy, but deed, that is deed they have submitted before the court. It is not the copy or certified copy. It is not certified copy. Trust deed, page 88. It is not certified copy, Lordship. It is copied from original.
Yes.
I am denied in my affidavit in reply, Lordship. Lordship, that is the Transfer of Property Act. 58 provides for mortgage.
TPF. Transfer property. Transfer property. Yes, which section?
Section 58 of the Transfer of Chapter 4.
Yes.
Mortgage here, Lordship, is defined.
Hmm.
A mortgage is the transfer of an interest in specific immovable property for the purpose of securing the payment of money advanced or to be advanced or to be advanced by way of loan or existing or future debt or performance of an engagement which may give rise to pecuniary liability. They have not provided any loan. I have not taken any loan. They have not handed over my vehicle. Since the filing of the Bakijai proceeding, I have stated same thing. Then there is simple mortgage. They have mentioned of the equitable mortgage on the basis of doctrine of equity, Lordship. Mortgage by conditional sale, then English mortgage, whether it is English mortgage or mortgage by deposit of title deeds, I have given. If they claim that is not also in proper manner, Lordship. Now they wanted to take possession of the property after 20 years. Section 69 of the Transfer of Property Act. Power of sale when valid.
Yes.
A mortgagee or any person acting on his behalf shall, subject to the provision of this section, have power to sell or concur or selling the mortgage property or any part thereof in default of payment of the mortgage money without the intervention of the court in the following cases and no other, namely, where the mortgage in an English mortgage and neither the mortgage nor the mortgagee, mortgagor or not the mortgagee is a Hindu, Mohammedan or Buddhist or member of any other race, tribes and class from time to time specified on this behalf, the state government in the official gazette. Where a power of sale without the intervention of the court in expressly conferred on the mortgage by the mortgage deed, the mortgagee is the government. where a power of sale without the intervention of the court is expressly conferred on the mortgage by the mortgagee by the mortgage deed, and the mortgage property or any part thereof was on the date of execution of the mortgage deed situated within the town of Calcutta, Madras, and Bombay, or in any other town or any area which the state government may by notification the official gazette specify it in this behalf. That should be clarified by the FC. This is the condition for taking possession of the property. And regarding limitation of the, they have claimed I have taken money in the year 1987. Now it is under Limitation Act. There is nothing to show that.
Limitation Act. Well. Last open দেখা হয়ে আছে ঠিক করিয়া আজকে তা Yes.
Article 64. Limitation period. Oh no, 63, Lordship. Article 63, Lordship.
Yes.
For possession of immovable property mortgage, 12 years, when the mortgagee become the entitled to possession within 12 years. In the statute, there is nothing mentioned. That is why about the taking possession of the property, then it will come under Article 137 of the Limitation Act. Lordship.
Yes.
137.
3 years.
3 years. 12 for mortgage, and that is if there is no mention about any period of limitation, then it is 3 years.
Anything else?
Let me-
Yes.
May it please, your lordship. My lord. First, my learned friend has submitted that earlier an order was passed, my lord, by Honorable Justice J.C.K. Roy,
Yes.
which we have annexed as Annexer 1 at page 22 of our reply.
Yes.
Affidavit in opposition.
Page?
Page 22.
Yes. 11/11/2024.
Yes, yes, my lord. Page para 2, my lord. The purchase of the pre-used minibus bearing registration number so and so
for a defaulting loanee was financed by the AFC, and accordingly a loan of rupees 1,60,000 or was sanctioned to the petitioner, but the minibus continued to remain registered with the defaulting loanee, Ratul Molla Bujorbura, and the petitioner, despite of hire purchase agreement and the loan, was unable to earn any profit from the minibus. Consequently, the petitioner approached the AFC for either cancellation of the hire purchase agreement or to facilitate registration of the vehicle in the new owner's name. To recover the outstanding dues of the minibus, a recovery proceeding was started by the AFC in 1993 by registering a Bakijai case. And in this proceeding, since the vehicle stood in the name of the original owner, the Bakijai certificate officer had order dated 27/1/99 released the petitioner from any loan liability to the AFC on account of the minibus. But 10 years thereafter, the second recovery proceeding was started by the State Financial Corporation, invoking Section 29 of the SFC Act, and the AFC took possession of the hypothecated property of the hire purchase on 1/8/2008. Although the petitioner is unrepresented in court, Mr. LP Sharma submits that the AFC has notified the non-performing asset loan settlement policy in March 2014, and under that policy, the NPA can be settled subject to realization of the principal outstanding as on 31/3/2013 and the present value and the security whatsoever is higher. Considering the above projection made by the advocate C. LP Sharma, I allow the petitioner to apply to the AFC under the NPA loan settlement policy, and the competent authority of the AFC is directed to consider the petitioner's representation on merit in accordance with their notified scheme. To facilitate the exercise, the petitioner shall furnish this order along with their representation within 2 weeks from today, and the competent authority of the AFC is directed to consider the representation with a speaking order within 6 weeks thereafter. The impugned recovery proceeding under the AFC Act will abide by the decision of the competent authority in terms of this order. It is ordered accordingly. My lord, the Assam Financial Corporation is a corporation, my lord. It is a not private property, my lord. Your lordship may be pleased to see page 24. In this petition, my lord, they stated that they did not know about the dismissal of the case. That is not correct, my lord. A copy by the High Court was sent to him. Page 24. I have given the EA. So earlier also they approached with the same fact regarding Bakijai case, regarding Section 29 application, and thereafter they were given an opportunity to approach the corporation regarding the NPA account. Now my learned friend has stated that all the signatures are false. What prevented them to file a criminal case or to represent to the AFC that these are not my signature, I have not taken any loan? Nothing. After this order, my lord, your lordship may be pleased to see page 25. We intimated the petitioner that now the managing director was appointed, so you approach the authority. Then at that time, my lord, the loan was sanction amount was 1,12,000. That's why, my lord, all the documents shows 1,20,000. Subsequently, my lord, your lordship may be pleased to see annexer, page 30, my lord.
30.
Page 30, already my learned friend has pointed out. Then also I am pointing, my lord. This is to inform you that I am unable to run my vehicle number AMK 3005 minibus, and as such, I have not been able to repay the dues. That is a different loan, my lord, Ratul Molla. Then now I have found a buyer, namely Sri Ratna Goswami of Polasbari, who is willing to take over the liabilities of the vehicle. You are requested to please transfer the vehicle to Sri Goswami and save me from the burden of the liability, for which act of your kindness I shall remain ever grateful. Then, my lord, your lordship may be pleased to see, Next page. Page 31. This is written by Ratna Goswami, that is the petitioner. I am happy to inform you that I have desired to buy the minibus number AMK 305, which belongs to Sri Ratul Manda Bujarbura. The bus was already financed by Assam Financial Corporation. For the above purpose, I want to pay rupees 10,000 to your corporation, and I agree to give all necessary documents along with land mortgage. This is, my lord, 14/11/84.
Same date.
Yes. Same day, my lord. Same day. Then, my lord, next letter, my lord, page
You
32.
can you see the endorsement on the left side at page 31? What is the date of the endorsement? 11/6/85. You took 7 months to endorse it.
Yes, sir.
It is actually office note, my lord.
Now, office note,
Office
the
note,
application was given in November 84. Then you make Sri Muzumdar, please make a note for transfer of the ownership of file
Yes.
of so and so.
Actually, my lord, what happened? Thereafter, my lord, he did not take any step. In the next letter, my lord, it will be reflected. It was properly reflected. Page 32, my lord. With due respect, I inform you that minibus number AMK 305 is already allowed to transfer from Sri Ratul Malla Bujarbura to Sri Ratna Goswami. But I, Sri Ratna Goswami, am so sorry to inform you that this case is unable to, actually some missing word is there, is unable to meet on July 85 due to my serious illness. That's why, my lord, that note was given 85. Now I abide by your rules and regulation, therefore kindly transfer the car to me. That is in 86, madam. Thereafter, my lord, this page 34, my lord,
Yes.
page 34, that is the note. my lord.
Schedule, payment schedule. Payment schedule,
Eh,
repayment schedule.
yes, my lord. That is, I, Ratna Goswami, has duly executed all these documents, etc., for transferring the loan AC of vehicle of Sri Ratul Malla Bujarbura to his own name by taking the assets and liabilities of Sri Bujarbura, so and so. Sri Ratna Goswami's repayment schedule is given below for
Yes,
necessary
repayment
correction in the loan. That is
Yes.
in, my lord, in 87, after the execution of the document.
Yes.
Then, my lord, he issued this DP note, my lord, at page 35. On demand, I see Ratna Goswami,
Yes,
son of
yes.
so residing of village Pogdar in the state of Assam, promised to pay the Assam Financial Corporation a sum of rupees 1,60,000. Because, my lord, originally 1,12,000, but it at that time, my lord, in 1987, my lord, it comes to 160. So loan was granted, revised to 1,60,000. Then it is important, my lord. Annexure 10, page 37. That was also written by Ratna Goswami. I regret to inform your office, your letter, number so and so, dated Guwahati.
Korita, let us cut things short. Let us come to the point which we need to adjudicate. There is an adjudication already done by this court. Till 1994, there was no de jure transfer of the property, namely the bus, from the original purchaser
Yes,
to the name of the petitioner.
yes.
And this fact was taken note of by the recovery Bakijai officer. Bakijai proceedings were dropped. There was no
But,
further.
one interesting thing is there, my lord. Bakijai officer observed till 84. Your lordship,
Yes.
till 84, that was not transferred.
No, not till 84, 94. 94. 1994.
1994. 1994.
Now that proceeding, the order of the Bakijai officer is not the subject matter of any further challenge. This court, while disposing of WPC 3474 of 2008, by the order of 11/11/2014, has taken note of this. But at the same time, petitioner's counsel was not there. We are not on that. We are on the aspect that from the side of the corporation, this court was apprised that there is a policy for settlement.
Yes.
So the petitioner was given liberty to approach and to settle the matter by a speaking order. That is not done. That will not revive the point of law. Till 1994, the vehicle was still in the name of the original vendor. These are matters. De jure owner was still the that Ratul Molla Buzarbura. We do not know the facts, but this is a part of the record. Now, if the vehicle was not even transferred to the name of the petitioner, we are not going with the allegation that Ratul came, forcefully took out the vehicle. We are going by the papers because we have to decide on the basis of papers.
Actually,
Now,
my lord,
if the ownership was not even transferred,
later
how
on,
do
my
you,
lord, from
how do you
this-
enforce a mortgage?
No, my lord, from this annexure page 37, my lord, it will be clear
Yes.
that although it was transferred, although he took the loan, my lord, he did not take the insisted for transferring because
So we did,
this,
so
this letter will show that the repairing and other costs are more.
those are different aspects. We are not going to the facts.
Yes.
We'll go by the papers. Kindly show that at the time when you took steps to enforce the mortgage, the property in question for which the mortgage, for which the loan was given, was in the name of the petitioner. If you can show that, we dismiss this case.
Loan was transferred, my lord.
No, where is the, not the loan, whether the property. Loan cannot be, loan is on the basis of a property, namely a minibus. Minibus admittedly as per record, still 1994 was in the name of the original purchaser.
Yes.
We do not know whether the petitioner is in hands in glove with Ratul. We do not know. It may also be a fact that loan is transferred, you do not transfer the property. But can you go against the petitioner for a property which has not even been transferred to her?
Actually,
We are not even in the allegation that the vehicle never came to her, no loan was given, never given to her, not even going on to those matters. Let us assume that 1,12,000 was sanctioned, given to her, but the subject matter, namely the minibus, because it started from where? It started from a letter by the original purchaser. I am not being able to run. I have got a purchaser. Kindly transfer it.
Yeah.
But was the transfer made? We have not even asked you the question of limitation also, which will come subsequently. But first, whether at the time of initiation of the proceeding,
actually,
the bus in question was in the name of the petitioner.
under section 29, my lord, there is no limitation. First thing. And apart from this,
No,
my
if
lord,
there is no limitation, you have to fall back under Article 137.
until and unless as this is the provision, my lord, given under section 29, my lord, to the that is the right of the corporation, my lord. They can take over the property.
That is why we have not even put the question on limitation. We are just asking a simple question. At the time when you had initiated a proceeding for recovery of the loan, was the bus in the name of the petitioner?
Actually,
The immediate question would be whether the recovery officer, Bakija officer's order was put to subsequent challenge.
some facts are actually missing.
See, Mr. Kolita, public money is involved. We are concerned about that.
Yeah.
You are not a private body. You are having public money, and you say that public money was extended to her.
And corporation is bound to dispose of the loan account, my lord. That is the problem. So they have ultimately taken resort of the section 29, my lord. There is some gap, it is correct, from 99 to 2008 or something like that, my lord.
And you see the section 29 notice is, can you see the date? 19/7/2008.
Yes. From 99 to 2008, my lord, no steps were taken. That is correct. They have also agitated that point, my lord.
2008. And the order of this court of 11/11/2014 is after that notice. 11/11/2014, court has already taken into consideration regarding the
Because-
order of the Bakija officer.
Because in the meantime, they filed the application, my lord, before this honorable court. And honorable court passed the order to approach the corporation, but they have not approached, my lord. Thereafter again, after this, my lord, after issuing this notice, second notice, my lord, they filed this writ application. But the submissions, other submissions, my lord, that Bhuvneshwar Goswami did not execute, his signatures are.
Those will not go into, those we
these
may not
are-
have the expertise to go into. We are not a court of facts, we do not know. It is for them to prove, it is difficult for them to prove.
Actually, my lord, they could have very well approached the corporation, that these are the things, these are for these things I cannot.
Was the vehicle ultimately transferred to the name of petitioner? Did you do that exercise?
Yeah.
Was the vehicle ultimately transferred to the name of the petitioner at any stage?
Actually,
Do you have any documents?
they have submitted certain documents, my lord. Actually, there are some tax due from the owner. So, my lord, this petitioner also did not insist for taking this, because he will have to pay all the taxes, etc. They have filed, my lord, these documents, page 20, annexure 1,
Of your affidavit?
their application, my lord.
Writ application, page 20
Page 20, my lord,
of the writ petition.
their writ petition, my lord. Return here with the report dated so and so 88, and the tax related to the vehicle of AMK 3005, hereby exempted, but on account of the vehicle is not running on the road since 1985, but a penalty of ₹500 is hereby imposed due to non-submission of Form H.
You kindly see who
It is-
copy mark to.
That is the
Original owner.
original one, right? That's
It is
still.
not my-
Then next, my lord, with reference to the annexure 2, with reference to the above, I am to state that the owner of vehicle number so and so may be allowed to pay area taxes. That is also Ratul Mollo. Then third, my lord, annexure 3,
94, page 90, this is of 1994.
94.
Ratul Mollo.
actually at that time, my lord, perhaps he applied for exempting the taxes and other things. Then annexure 3, my lord, 94. With reference to your letter quoted, I am to state that the ownership of the vehicle stands in the name of Ratna Goswami of village Polasbari, Kamrup, as per the latest hire purchase agreement with Messrs Financial Corporation Guwahati. Even though formal application for transfer of ownership has not been made by the previous owner, Sri Ratul Malla Bujurga Rihabariga.
Where are you reading?
This is the State Transport Authority.
Page
22, madam.
22.
It is their documents, madam.
Yes. Reference to have to state ownership will stand in the name of Ratna Goswami. But then now this is as per the hire purchase agreement.
Yes.
There is no formal transfer. The document of hire purchase shows that the petitioner has taken over.
No, madam. What this document state, my lord?
Yes.
Ownership of the vehicle stands in the name of Ratna Goswami.
Which, as per which document? As per the latest hire purchase agreement.
Yes.
As per hire purchase agreement. But according to corporation, there is no hire purchase agreement, only loan application.
This is reflected in Bakija proceeding also.
Mr. Kolita, we can understand the practical aspect, but we cannot ignore the aspect whether the registration was changed to the name of the petitioner. That was not done till 8/8/1994.
Only one thing, my lord. Your lordship may be pleased to see their brothers, his brothers one letter, my lord.
Page
Page 27, my lord.
27. 27.
27, my lord.
Yes.
Of my reply.
Of your reply. Okay.
Of the, that is affidavit in opposition, my lord.
Yes.
Most respectfully, I beg to state.
Just a minute, please.
Annexure 4, my lord.
827 you had said?
827. Most respectfully, I beg to state that my elder brother Sri Ratna Goswami took a loan from the corporation about 30 to 33 years ago for purchasing a pre-used minibar, and accordingly the Assam Financial Corporation transferred the loan account to my elder brother Sri Ratna Goswami. But I am sorry to inform you that the loan has been transferred, but the minibus was not transferred, for which we had to repay the loan. But we had no right about the ownership of the vehicles. Therefore, the Assam Financial Corporation taken legal steps for recovery of the amounts from Ratna Goswami. Sir, the financial condition of my elder brother is not sound, and my elder brother is not in a position to repay the loan. As younger brother, it is my duty to help my brother, and I am somehow running a small industry in my house and running my family. Therefore, I request you to kindly waive 50% of the principal amount. Allow me to pay the said amount within 8 to 10 months and give funds to free from the loan. That is in 2015, madam. So, madam,
Sorry,
just a minute.
sorry.
What they stated that they have not taken the loan, that is not correct, madam. But some gap is there.
Yes, you're correct.
Some gap is
Yes,
there.
yes.
Okay.
Lordship, the one Niranjan Goswami, he is the brother, but he has no relation with the petitioner. That is written on 23/2015, Lordship, when the AFC visited, or after issuing last notice, issuance of last notice in Annexure 8 of the my petition, Lordship. Thereafter, probably he went to, because it is a joint family property, that was not partition. That is why he approves, but petitioner has no knowledge about it.
Perhaps, my lord, at that time, it was given, so
I have
advice given to him that you don't write because it will be an ambition.
Who has
So his
how-
father-
how
father
am I-
indirectly- That is not,
my senior counsel
not,
can
not
say
allegation to you.
presumption,
but somebody
take
perhaps
presumption that
advice.
whether he is related, because it is a joint family property. There's some person who went there. That is why probably there was some he went there. And I have specifically mentioned about the joint family property in the name of father of the petitioner as well as his uncle. But there is no
Regarding
no
joint,
objection has been taken from the uncle of the petitioner.
regarding joint family and other
That is
things,
matter of
law will
fact,
take its own course,
matter-
my lord.
But they cannot go and take the possession of the property.
And regarding equitable mortgage, my lord, equitable mortgage need not need,
That is the,
registration is not required.
in mortgage, there is in India, that 4 kinds of mortgage is mentioned. Equitable mortgage, they must have to show that they have granted loan.
Is equitable mortgage defined?
Yes, Lord Shiva.
Is
I'll-
it defined?
Yes, Lord Shiva.
Let us see what is the definition.
I am giving.
Only one letter is sufficient.
No, what is an equitable mortgage?
It is from equity, Lordship.
No,
Doctrine
no,
of
where do you find the definition?
Lord, they have mentioned, let them explain. Lord.
No, you have led us to the definition of mortgage
Yes,
in 58.
58, Lordship. The mortgage policy is what about it? A mortgage is the transfer of a interest in specific immovable property for the purpose of securing the payment of money and advance and to be advanced by way of
So what
loan.
is an equitable mortgage? Is it
There
defined?
is nothing in India.
There is no definition of equitable
Yes,
mortgage.
in a Transfer of Property Act. Equitable mortgage is that is doctrine of equity.
Concept of equitable mortgage is accepted, my lord, only by a letter. You will.
Then the Lordship order or
Deposit of title deeds, my lord.
then title deeds. And order for 34 Rule 15 of the CPC they must follow that all the provision of 34, order for 34.
No, we are not on the subject matter of, on the mortgage property. Mortgage property is the land in question. But the purpose of the loan was to purchase a minibus
Yes.
from the original vendor, one Ratul Molla Bujarburo. But on record, it appears that the lawfully the matter, the vehicle was not transferred till 1994 in the name of the petitioner. Though perhaps on facts, the petitioner was running the vehicle, because we also find one communication that the vehicle had suffered some damage. It was in a garage at Beltola. So some time was also sought for to make some repayment, that the vehicle was not being able to be operated. So, and that letter was written by the petitioner. It seems that, as a matter of fact, the vehicle was indeed taken over by the petitioner, but on records, it was still in the name of
Yes.
Ratna,
Ratul.
Ratul.
Ratul Malwa.
So if it was in the name of the original or somebody else, would you have,
That was also observed by
that
the.
is observed by the Bakide officer. In the
District
second page.
Commissioner letter is there, my lord.
Yes, second page. That is an hindrance. Otherwise, public money has.
Thereafter, my lord, they have approached this honorable court. Honorable court, they failed to appear. Thereafter, chance was given to repayment
not-
or whatever they
No,
like.
that we have read and reread. That was not, this court has not said anything about the Vakide officer's order.
It
It said that since submission had come from the corporation, that we have presently we are having a policy where perhaps the matter can be settled. You file an application, it will be disposed of by a speaking order.
Yes.
Petitioner did not do that. And which led to,
He had no
the-
knowledge about what I have specifically mentioned in my petition.
Petition, copy of the petition was sent by High Court. I have given that.
No, High Court, it is to
if it is
the-
sent by High Court, will it mean that he or she has received
It is High Court to the AFC lodge,
No, no, no.
not the EFC lodge.
You also, you also.
Yes,
the-
I am. No,
Just see, I have given the copy.
no,
Ma-
copy. It is
Mr.
a
Kolita, from the copy mark,
copy. mark.
it is proved that it was indeed sent by the High Court.
Yes.
But it will not prove that he or she has received it.
Yes,
Okay, we'll consider.
Yes.
Like,
What to do. Yeah. We'll do one thing. We'll pass the judgment at 2 o'clock here in the open court. Okay. We'll pass the judgment in the open court at 2 o'clock. We'll not make this CAV, otherwise there are 2 more CAVs. Yes, next.
I think to
yeah, it is open court.
Please, your lordship.
It has been and it will be modified. Yes,
Respondent were supposed to come up with an instruction, lordship, today
what is this
regarding the filing
matter?
of the FR. This is regarding the transfer of the Hatigao PS case to CBI, lordship. Now, they have intimated on the last occasion.
Yes,
that
yes, yes,
it has
yes,
been submitted.
yes,
So the respondent were directed to come up with the copy of the FR, lordship.
yes.
Final report.
The FR was submitted on 26/8/2023.
Lordship, we did not receive any
Has it been
information regarding
accepted?
the same.
Has it been accepted?
My lord,
No, lordship, because I am the informant, lordship.
No, no, no.
Otherwise. Okay.
At times, without even notice, you are not
Yes,
aware of
yes,
it.
yes.
We are only on that part. FR, he has already said that it ended up in a final report.
26/8/2023.
Mr.
Yes, my lord,
Das,
that this small only information has been.
you get the information, this you had already submitted final report. It ended up in a final report. This is,
My lord.
Because your lordship, if your lordship looks into the photographs, your lordship will kindly see.
that we have seen.
Lordship.
You get that information,
Yes, my lord.
okay? If you have not got notice, you have a chance to appear before the learned court.
Yes.
And if the court is convinced about because the same, you should not lose an opportunity.
Lordship, the only difficulty is this, that the court below being a trial court will not have the power to commit this matter to CBI investigation. Only the
We are not on the
prosecution
part of,
court
no,
with the power.
we are not on the aspect of referring or to the CBI. You have also have an opportunity to convince the court that way if further investigation is called for.
Oh, by a different investigating agency, may it be CID or something else.
There are
Not by Hathi of PS.
heard Sri A. Bhattacharya, learned counsel for the petitioner. Also heard Sri N. Das, learned state counsel, as well as Ms. M. Kumari, learned standing counsel CBI. Full stop. Ms. R.S. Dewey, learned counsel is present for the respondent number 5. Para. Pursuant to the direction dated 28/7/2025. This court had directed the London State Council to take instructions on the fate of the acceptance part of the FR, final report, in fact, FR, by the learned court. Para. Sri Das, the London State Council, has obtained written instructions dated 1/8/2025 in the form of status report. Full stop. A perusal of the same, however, would reveal that the same is only confined to the aspect of filing of a final report, submission of a final report being by the FR number 552 dated 26/8/2023. Full stop. The query of this court was with regard to the fate of the report which has not been, which is not a part of the instructions placed before this court. Para.
26,
Three.
23.
Thus, the learned council, London State Council, prays for some more time to obtain the instructions with regard to the specific query put by this court. Mr. Das, your officer has not understood the order.
My lord,
Why should you repeat an order? Who is this officer
Hello.
in charge?
some Dwara, my lord, if I'm not
You
wrong.
call him at 2 o'clock.
Well, can it be?
No, why? What is this? We asked for the fate of the FR. He says that FR has been submitted. If he doesn't know, say that I do not know, I need some time. Have you seen the order of this court 28/7/2025?
Yes.
We don't play with things like this. Whether he's got merits in the case or not, we are not concerned with this. A very serious allegation has been made.
Yes, my lord. In fact, our letter is also very much clear, my lord.
Then what is this?
You are requested to provide the status of the investigation or copy of the certificate filed in the trial court by 3/8. That is, yes, sir. That is also very much clear.
No, we want what has happened to
Yes,
the
yes,
FR.
yes. I understand, my lord.
This FR is of 2023.
Yes, 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 yes.
We are in 2025.
Yes, yes. Yes. I'll get it, my lord.
This court also takes an exception with regard to the manner of furnishing the status report, which has confined itself to the fact of submission of the FR, which was already recorded in the earlier order. Full stop. Accordingly, on the prayer of the learned State Council, a last opportunity, another opportunity of a week is given to place on record the fate of the final report. The copy of the written instruction that is 1/8/2025 is kept with the records. Yes, list on Friday next.
Can I get the order, Mal?
This order you get an online copy, why should we give you another? Yes,
Next, Lordship.
Friday next.
8th.
15th, then we'll have it on
13th, some difficulties already there, Lordship. Can
we'll have it on 18th.
18th. Diplo, please, Lordship.
Yes,
Lordship, it will be difficult, if a bond is given of the 4,72,000 tax invoice. Because, here he has, undervalued the product, the code number, Lordship, are different, and our valuation, Lordship, will find that page 86, Lordship,
of
my affidavit, it will be, page continuity, page 86, Lordship.
86.
Yes, Lordship.
How much is your value?
Lordship, the first part, Lordship,
6,72,000.
no, Lordship, CGST 168, state tax 168, cess is 672. Then the penalty next column, Lordship, heading number 2. Lordship, central tax 3,36,000. 56,000, sorry, Lordship, then again 3,56,672. All total, it comes to 23,522, Lordship.
No,
And here, Lordship, against this, he can file objection or reply, Lordship, and he will be giving only the bank guarantee, Lordship. Thereafter, the calculation, if any changes are there, then only he will have to pay in actual sense, Lordship. Now only the bank guarantee will be there.
Bank guarantee you can invoke.
Only
if he fails.
If he fails, Lordship.
If he fails, no, we may not be on the penalty part. Penalty would be subject to what the final outcome is there. We are on the value. Now he has made an assessment of the value. You said it has been undervalued. As
Yes.
per you, the value should be how much?
As per our Lordship,
Along with
12
taxes,
12
along with taxes should be not 12 lakhs.
yes, Lordship, at the
6,72,000.
calculation of tax, Lordship, in the beginning, manufactured tobacco, HNS code 2403, 15,000 kg,
Yes,
total value.
total
Lordship.
value. 12 lakhs.
Yes, Lordship.
Oh, total value is 12 lakhs.
What happened, Your Lordship? My
Because,
goodness, sir.
Lordship, if looks at his tax invoice, here, Lordship, he is paying only 5%. And with the code, tobacco are different items, Lordship. And the code number he has given is 2401. So obviously, it comes down, the tax rate, Lordship.
Because it is unmanufactured tobacco, Lordship. It's tobacco leaves, and they have calculated manufactured tobacco. Even it is not that case.
So, Mr. Soni, this will be factual aspect.
But
This
the-
court can
Therefore,
neither believe you, neither believe them at this stage.
therefore,
There is no evidence before us.
but therefore, at this stage, I am ready to pay. There are certain dispute regarding says is not implicated on unmanufactured tobacco.
We are not on the cess part.
But
We are
therefore,
only on the value which they have assessed is 12 lakhs.
but because they have consider it is manufactured tobacco, but this is not manufactured tobacco.
That aspect at this stage will not be able to.
But therefore, it is unmanufactured tobacco. Therefore, I suggested instead of bank guarantee, I may given a undertaking or MOV 8 as per their valuation 23 lakhs subject to reserving my all rights.
What is MOV 8?
No, MOV 8 is undertaking, bond, Your Lordship. It's bond.
Bond
Because-
will
because this
bond will not save the interest of the state.
Because
With the bond, you are out with the goods.
if,
Also, he'll be untraceable.
no, lordship,
next moment.
I have even my
Yes,
latest GST return is,
bank guarantee is what we are.
but it is my valuation of the good is only 4 lakh rupees, your lordship.
And lordship,
That is the dispute.
But that is a dispute, your lordship, my lord Messi. Since month has been passed, my 20% of the goods is lost because it's raw tobacco leaf, your lordship.
Mr. Soni, please try to understand. On factual issue, you
Because
may be correct.
Consider
But at this stage, we cannot side with
even
you.
my lord Messi.
When his document says that the value of the goods is
No.
12 lakhs.
Even my lord Messi, I saw that discrepancy in their goods, your lordship. My lord Messi, first MOV2 was forged one. Now, my lord Messi, we come to the MOV4. In MOV4, they come to the case that it is manufactured, but it is not in MOV1. Even my lord Messi, in MOV6, which is
What do you say about page 86?
please, your lordship, my lord Messi.
Page 86.
Page 86, before my lord Messi, page 80. Now, my lord Messi, it's MOV9 order.
Page?
Page 84. It's MOV9, the order. Before that, my lord Messi, come to the page 81, MOV7, the notice to pay me tax under 129(3).
MOV 9 is also 12 lakhs.
No, my lord may only see page 81,
81.
MOV7.
Yes, MOV 7. Yes.
Now, my lord may see discrepancy. Improper CN signature of proprietor or authorized representative was missing in invoice. This is the only discrepancy they have shown in MOV7. Now, my lord Messi, in MOV7, there is no date. They have me provided opportunity of hearing page 83 on 5 July 2025. Even they have not placed on record or upload on a portal, which is they out to do as per the SOP or as per the mandatory procedure. They have only shown MOV7 discrepancies that the signature is not in the bill. Even my lord Messi, after MOV7, they have to pass order under MOV9. In MOV9, the order is 26 June, back date. Even they are relying upon the order dated. Column number 11, date of service of order 26 June. Even interestingly, your lordship, page 87.
No, at page 83,
Please, your
a
lordship.
date was given to you for your appearance on
But
5/7/2025.
It was not even uploaded in online portal, which they out to have, even not it is served to the driver. Only MOV2 was served, and here they place on record the forged one and MOV2, your lordship.
Mr. Sodi, these are all allegations, counter allegations.
Therefore,
You try to suggest a
therefore,
thing whereby your goods we can strike a balance till the adjudication of the matter.
therefore, your lordship,
And for that, we cannot go into the merits of your case.
therefore, your lordship, at this,
They have assessed the value of the goods as 12 lakhs. You have assessed the value of the goods is 4 lakh something. We are not on the manufactured aspect, unmanufactured aspect. We have to strike a balance. What is the amount of a bank guarantee which you would be required to give? Because see, ultimately there is a dispute. This dispute, whether it is bona fide, mala fide, correct, incorrect, these will be adjudicated, worked out, but not today.
but therefore,
So, and today this is neither is this forum nor we have the expertise.
therefore, it is entire good value is 4,50,000. Even at this stage, I am ready to pay the bank guarantee of 6 lakh rupees, your lordship, more than the goods value, because it's raw tobacco, your lordship. Subject to final outcome of this petition, your lordship. Even I am regularly paying tax. This is my latest GST return, your lordship.
Okay, come at
Because,
2 o'clock. Okay,
Please,
we'll pass orders. We'll first pass orders in this, doesn't the way to dispose of them. Okay. ಇದು temporary it was. Or it would it.
Appointment today at 3:30. My learned friend is being for petitioner.
Okay. You could have had somebody else. Why are you waiting? Go. We'll have some item 17 matter. We'll have some other day.
Eight.
17 matter. Oh, we'll have it some other day. Don't
Other
worry.
day, we'll have.
Oh, item eight, huh?
Any convenient day, Milo.
On a request made by Sri
T. Barua.
Barua. Learned Standing
Standing
Council,
Council, NHAI.
NHAI. Matter is adjourned. Sri C. Barua, Learned Standing Council, NHAI, has expressed some difficulty and had prayed for adjournment of this matter. Some personal difficulties, huh? Para. Sri D. Barua, Learned Counsel for the petitioners are present. Para. In view of the same list, matter is adjourned to be listed when?
After 2 weeks, did you?
Of Friday?
This Friday.
Hmm.
This Friday. After 2 weeks. 2 weeks.
After, no, 17 matter, not 2 weeks.
No, 1 week. 1 week.
In the next week.
My lord, oblige.
Published.
Heard Sri M. Suni, Learned Counsel for the petitioner. Full stop. Also heard Sri B. Chaudhary, Learned Standing Counsel, Finance, within bracket Taxation Department, Assam. Full stop. Para. Please have your seat. In this case,
May I only, sorry, Tim,
Yes.
may I suggest only one thing? As per the instruction of me, our actual goods value is 4,72,000. It is not more than, because it's only leaves. They are suggesting us to pay 24 lakhs rupees. As per their say, good value is 12 lakh rupees. At this stage, may I request only one thing? As per they say, good is 12 lakh rupees. We will not claim the goods. Only conveyance may be released subject to outcome of this petition, because actual the good value is 4,72,000. If when we are not in position to manage the bank guarantee of 12 lakh rupees, because we are the small merchant, the amount which is not actual, and they are suggested us to.
how much bank guarantee are you in a position to
At
give?
the most, your lordship 6 lakh rupees at the most. And even as per the instruction of client, that 6 lakh rupees, we will also directly pay to GST department instead of bank guarantee to show our bona fide intention. Not even bank guarantee, directly subject to outcome of this petition, directly within 1 day. Tomorrow, we will transfer the 6 lakh rupees to the GST department, your lordship.
কি করো? In this case, notice was issued on 15/7/2025. And prior to the same, while an order dated 11/7/2025, while the matter was considered, an observation was made that no proceedings for confiscation without the leave of the court be initiated. Full stop. The said interim order was directed to be continued while the order dated 15/7/2025. Para. Thereafter, the affidavit by the department was filed, and when the matter had come up for consideration on 4/8/2025, the Learned Counsel for the petitioner had highlighted the aspect that the stand of the department as put in the affidavit in opposition dated 1/8/2025 was inconsistent, and there were discrepancies in the documents. Full stop. He had also made a prayer that the goods in question, being perishable in nature, and delay in adjudication of this matter would not serve the interest of would not serve the interest of either of the parties, an interim direction be issued for release of the goods subject to furnishing of a bond. Full stop. On the said issue, the matter was adjourned to enable the learned standing counsel of the department to obtain instructions. Para. The instructions have been obtained by Sri Chaudhary. Full stop. He has submitted that the goods have been undervalued and by drawing the attention of this court to annexure J for Jammu, of the affidavit in opposition, the learned standing counsel has submitted that the total value of the goods assessed is 12 lakhs. Full stop. He accordingly submits, he has further submitted that the penalty has also been assessed, which is stated in the said annexure. Full stop. Para. The Sri Soni, the learned counsel for the petitioner, on the other hand, has submitted that the aforesaid annexure J is an undated document and has not been served on the petitioner. Full stop. He has also emphasized on the aspect that the description of the goods is itself erroneously made, as according to him, the goods in question is unmanufactured tobacco, whereas the department has stated the same to be manufactured tobacco. Full stop. Para. On the as regards the allegation and counter allegation, which would require a detailed adjudication, this court is of the opinion that the said aspect would be taken up at the appropriate stage. Full stop. The present consideration is only on the aspect of whether the goods in question can be directed to be released on fulfillment of certain conditions. Full stop. Para. The learned counsel has submitted on instructions that the value assessed by the department is on a much higher side, which his client is not in a position to deposit. Full stop. On the other hand, Sri Chaudhary, the learned department counsel, has submitted that the aspect of submission of bond would be covered by section, where is it? Not to
Rule 140, section 129(1), and then rule read with rule
section
140.
129(1),
Read
read with rule
140.
not too good.
Even in transition.
The foundation, no?
Perishable goods 140.
129(1), just wait. Section
129.
Section 129(1), read with
Rule 140, Lordship. 140.
Even 141 applicable because it's perishable in nature. Rule 141 is it?
140. Of the, we'll have the Assam, AGST.
AGST, Lordship, there are some amendment, it's not here, but.
No, AGST, it's perimeter here of the AGST Act and the rules. He submits that the amount has been prescribed in the aforesaid provision. Full stop. Sri Soni had joined the issue by submitting that Rule 141(1) within bracket 1 will also come into play as the goods in question are perishable in nature. Full stop, para. Without going deep into the aforesaid aspect, comma, this court is of the opinion that the interest of justice would be served and the equities can be balanced if the goods in question are directed to be released to the petitioner, subject to the petitioner furnishing a bank guarantee. Full stop. As regards the amount of the bank guarantee, comma, this court has found that there is a disparity between the amount which the petitioner claims to be the value of the goods and the amount which has been assessed by the department. Full stop. By striking a balance, this court directs that the bank guarantee, if the bank guarantee is for an amount of rupees 8 lakhs, comma, the goods in question are to be released to the petitioner, full stop. While doing so, the department may impose any other condition to secure the presence or otherwise of the petitioner so that the proceedings initiated can be are not hampered in any manner. Okay. List this case after 2 weeks.
Yes, goods including conveyance or lordship, otherwise technical aspect would again come.
What conveyance?
So, the truck. Otherwise,
Truck is not the subject matter.
because truck, goods are in truck, your lordship, and they have seized the truck and goods
The-
both.
Goods are with the truck.
While releasing the goods, the aspect of the conveyance in which the goods are where are conveyance containing the goods would also be taken into consideration by the department.
Or one only last thing, they may be provide the details of bank guarantee, so we will do necessary procedure within 2 or 3 days, your lordship.
Lots of bank, that's
Because
procedure
some-
part, lots of he will have to approach the authority.
It will take.
The petition regarding the details of the bank guarantee, comma, the petitioner may approach the department, and on such approach, the department would provide the details. Yes.
Interim relief may be extended, your lordship.
Yes, the interim order passed earlier to continue till the next date of listing. Yes, next.
Highly obliged, I am grateful.
8 lakhs. Huh? What did you have? What did you close? এটা লাইন লগাই দিলো এটা পিছত মোক মনত কৰি দিবা The instant petition under Article 226 of the Constitution of India has been instituted against the action of the respondent corporation in taking steps for sale of the joint family property of the petitioner in the name of providing loan, full stop. The primary contention of the petitioner is that no such loan was provided or sanctioned at any point of time. Para. As per the facts projected, the petitioner had approached the AFC for purchasing a minibus on hire purchase basis, full stop. However, the corporation had convinced the petitioner to purchase a second-hand vehicle from an earlier borrower who was unable to repay the amount, full stop. It is the case of the petition that though a talk was held in that issue, no substantive, there was no actual advancement of loan, and it is also alleged that the signature of the petitioner were taken in some papers, including the papers of the joint family property. It is the categorical case of the petitioner that neither any loan nor any vehicle was provided to him, full stop. The AFC had subsequently instituted a Bakizai proceeding against the petitioner, which, however, was rejected vide an order dated 27/1/1999. Full stop. 9 years thereafter, the AFC had issued a notice which was also the subject matter of writ petition WPC 3474 of 2008, which was disposed of by this court vide an order dated 11/11/2014. Full stop. While the said order passed in absence of the learned counsel for the petitioner, this court had, however, recorded the aspect of dropping of the Bakizai proceeding vide the order dated 27/1/1999. Full stop. However, on the submissions made on behalf of the corporation that a scheme for settlement was in vogue, this court had made certain observations that the petitioner would be at liberty to approach the corporation for settlement. Full stop. It is the case of the petitioner that he was not aware of the order which was passed ex parte. Full stop. Be that as it may, on 19/3/2015, a notice was issued by the respondent corporation to the registered valuer to submit a valuation report, and a copy of the said notice was marked to the petitioner, which gave rise to the present cause of action. Full stop. This court vide an order dated 13/5/2015 had passed an interim order which has been extended from time to time. Para. I have heard Ms. M. Deb, learned counsel for the petitioner. I have also heard Sri P.K. Kolita, learned senior counsel, assisted by Ms. T. Goswami for the respondent corporation. Para. Ms. Deb, the learned counsel, has submitted that once the Bakizai proceeding was dropped vide the order dated 27/1/1999, which was also recorded by this court in its order dated 11/11/2014, passed in WPC 3474 of 2008, the impugned notice could not have been issued. Full stop. She has also highlighted the observations made in the order dated 27/1/1999, passed by the Bakijai officer, who has recorded that till the year 1994, the vehicle in question still stood in the name of the earlier owner and not the petitioner. Full stop. She has also submitted that the premises on which the respondent corporation had proceeded was fallacious, as the petitioner is not an industrial concern. Full stop. She has also submitted that joint family property was sought to be made the subject matter of an imaginary mortgage in which the petitioner had not given any consent to. Full stop. She has submitted that so far as the notice under Section 29 of the AFC Act is concerned, dated 19/7/2008, the same was the subject matter of challenge in the earlier writ petition, in which this court had made necessary observation regarding the vehicle in question, and also the vehicle regarding the dropping of the Bakijai proceedings. Full stop. It is highlighted that till 1994, the vehicle was in the name of Ratul Molla Bujar Borua and was never transferred to the petitioner. Full stop. By referring to the affidavit in opposition filed by the respondent corporation on 2017, the learned counsel has submitted that though the land in question has been stated to be mortgaged, such mortgage was not a lawful mortgage. Full stop. She has drawn the attention of this court to the transfer of to Section 58 of the Transfer of Property Act, and has submitted that the ingredients required to constitute a lawful mortgage under the aforesaid provision are not present in the present and are not present. Full stop. She has also drawn the attention of this court to the documents allegedly submitted by the earlier borrower, namely Ratul Molla Bujar Borua, and the application by the petitioner. Full stop. This court has noticed that while both the applications are of a similar pattern and dated 14/11/84, the endorsement on the application of the petitioner is of 11/6/1985. Full stop. The learned counsel has also submitted that though a payment schedule was allegedly notified, the petitioner was not having any knowledge of the same. Full stop. Similar submission has also been made so far as the DP note dated 27/8/1987 is concerned. Full stop. It is also averred that the earlier borrower had forcibly taken back the possession of the vehicle, and in this regard, the learned counsel has referred to the averments made in paragraph 4 of the writ petition. Full stop. She has also submitted that there is inconsistency in the amount of loan concerned, full stop, by referring to the notices dated 18/4/1990, 16/3/1993, and 19/7/2008, the Learned Counsel has submitted that the respondent corporation is itself not certain about the loan amount which differs from every notice. She has also submitted that the impugned notice dated 19/7/2008 was issued after a period of 18 years and clearly hit by limitation. Full stop. The scissor list annexed to the affidavit in opposition has also been highlighted, and a perusal of the same would show that the name of the earlier borrower, Ratul Mollo, was struck off and the name of the petitioner was inserted by hand. Full stop. The deed of guarantee dated 26/8 the deed of guarantee and the irrevocable power of attorney allegedly executed by the father of the petitioner on 26/8/1987 have been denied by submitting that the father of the petitioner was an old and frail person who was also blind, and therefore such deeds were not possible to be executed. Full stop. She has also submitted that apart from the fact that the father of the petitioner had expired almost at the same time in the year 1988, there were certain endorsements in the said deed which itself will raise doubts on the bona fide on the part of the corporation. Full stop. She has also submitted that many of the documents which have been annexed to the affidavit in opposition would show that the dates were not filled up. Full stop. By drawing the attention of this court to the Limitation Act, more particularly to Article 63 and Article 137, the Learned Counsel has submitted that the present action is otherwise barred by the law of limitation. Full stop. The Learned Counsel accordingly submits that interference of this court is warranted in the present case. Para. Per contra, Sri Kolita, the Learned Senior Counsel, has submitted that the amount that firstly the issues raised are factual in nature, which are disputed by the corporation and would perhaps not be appropriate for a writ court to enter into. Full stop. He has otherwise submitted that the amount involved is public money, and therefore the corporation had all the rights to institute a proceeding for recovery of the same. He has categorically submitted that under section, what is the section of the AFC Act, no period of limitation is prescribed. What is that section 29? 29. Under section 29 of the AFC Act, no period of limitation is prescribed. Para. The Learned Senior Counsel has also submitted that this court, while passing the order dated 11/11/2014 in WPC 3474 of 2008, had made a specific observation giving liberty to the petitioner to approach the corporation for settlement of the dispute, and in spite of the same, the petitioner had failed to do so, and therefore would be precluded from approaching this court again. Full stop. By drawing the attention of this court to the affidavit in opposition wherein the order dated 11/11/2014 has been annexed, comma, the learned senior counsel has submitted that copy that irrespective of the fact that the petitioner was not represented, the copy of the order dated 11/11/2014 was marked to him, and therefore the petitioner cannot feign FEIGN, feign ignorance of the said order. It is he has also submitted that though the petitioner has made allegations of forgery, the same was never intimated to the corporation and neither any police case filed, and therefore such allegations cannot be made at this stage. The learned senior counsel has also drawn the attention of this court to various communications made by the petitioner and the earlier borrower, which would bind the petitioner to the fact that the vehicle in question was indeed transferred to the petitioner as a matter of fact. Full stop. He has also submitted that the deeds were registered before the appropriate authority and the petitioner had also executed a DP note dated 22/8/1987. Full stop. He has also highlighted the aspect that the liability was admitted, which would also appear from the letter dated 23/2015 issued by the brother of the petitioner, whereby an admission was made regarding the loan in question. Full stop para. As regards the alleged inconsistency in the amount demanded, comma, the learned senior counsel has submitted that the notices are of different periods, and it is only because of the interest factor that the amount has differed. Full stop. However, he submits that the original amount was rupees 1,12,000, which would appear from the documents annexed to the affidavit in opposition. Full stop. Para. The learned he accordingly submits that taking into consideration all the aforesaid facts and circumstances, the writ petition is liable to be dismissed. Para. The rival submissions have been duly considered, and the materials placed before this court, including the placed before this court, including the pleadings, have been duly considered. Para. It transpires that the present dispute originated from a move to finance the petitioner by the corporation for taking a bus on hire purchase in the year 1987. Full stop. It also transpires that the vehicle within bracket minibus was not a new vehicle, but was owned by one Ratul Mollo Buzarbura, and there is a communication dated 14/11/1984 by the said borrower expressing his inability to repay the corporation, and that he had found a vendor in the vendor within bracket petitioner, or not vendor, he had found a buyer within bracket petitioner who
who was interested to have the minibus, and therefore the loan accounts be transferred in the name of the petitioner, full stop. What, however, is important to note that the vehicle in question was never transferred to the name of the petitioner, at least till 1994, full stop. The earlier action of recovery of the amount by taking into resort the, what is the name of the Bengal Public Demand Recovery Act?
Bengal, yes.
Bengal Public Demand Recovery Act had culminated in an order dated 27/1/1999 passed by the Bakizai officer, full stop. The observations made in the said order are relevant, which are extracted herein below, page 23, Mokodima. Full stop. It also appears that the corporation did not take any steps towards challenging the aforesaid order, which had attained finality. Full stop. Full stop. However, after about 9 years, the corporation had taken an initiative for recovery, which was the subject matter of challenge in the earlier writ petition instituted by the petitioner, being WPC 3474 of 2008, which was disposed of by this court via order dated 11/11/2014. Full stop. In the said order, which was passed in absence of the learned counsel for the petitioner, this court had, however, recorded the aspect of dropping of the Bakijai proceeding via the earlier order dated 27/1/1999. Full stop. This court had, however, also observed that the settlement policy, which was said to be in vogue by the learned counsel for the corporation, could be resorted to by the petitioner for settlement of the matter. Full stop. The petitioner claims that he was not aware of the order which is disputed by the corporation. Full stop. Without even going to the aforesaid aspect, what is of relevance is that there is nothing on record to show that the vehicle in question was ever transferred to the name of the petitioner. Full stop. To the contrary, the available records would show that the registered owner of the vehicle still continued in the name of the earlier borrower, namely Ratul Molla Buzar Borua. Full stop. The said aspect has not been able to be disclosed by any materials by the learned senior counsel for the corporation. Full stop. Para. As regards the various documents enclosed to the affidavit in opposition and relied upon by the corporation, the learned counsel for the petitioner has denied the veracity and authenticity of those documents. Full stop. This court is, however, of the view that such issues will be in the realm of disputed questions of fact, and this court would not be in a position to make any comment on the same. Full stop. Para. Be that as it may, what has been be that as it may, the relevant aspect concerning this present dispute is the aspect as to whether the vehicle in question was transferred to the name of the petitioner. Full stop. As noted above, there is nothing on record to substantiate the claim that the vehicle was actually transferred to the name of the petitioner. Full stop. In absence of any such material, the demand made by the corporation, which is the subject matter of this writ petition, cannot be held to be sustainable. Full stop.
this court has also noticed that the transaction relates back to the year 1987 and the Bakizai proceeding itself was dropped in the year 1999. Therefore, the present action which has been initiated vide the notice dated 2015 is otherwise barred by time. Full stop. In view of the above, this court has no other alternative but to allow this writ petition. Full stop. The interim order accordingly is made absolute. Writ petition stands allowed. Yes.
Lordship, the original documents, my property, that is in the AFC, Lordship.
You apply, they'll see, look into it.
Oblige.
Is it a part of the prayer?
No.
I don't think so. You apply?
Oblige.
Kept in my deal. Last only you. Yes, item number?
Lordship, my lord, in this case, Dipankar not will appear, my lord. He is in Valuation court number
I will raise strong objection, Lordship.
time being.
Please peruse the record on, this is the fourth occasion they have taken time. Always he remained tied up.
Time being.
Because of the busyness, the petitioner could not suffer.
Yes, what is your case?
Lordship, this petitioner organization is a wholesale consumer cooperative society registered under the Assam Cooperative Societies Act 2007. And as per the bylaws of the Act, the petitioner organization is entitled to do business with the PDS article. But my case is that an organization which is not registered as a wholesale consumer cooperative societies, the authorities are allotting the PDS articles to this organization. They have allowed this organization to do business with the PDS article. And earlier, there are 87 fair price show tagged with me. And when this organization came into existence, they have taken 46 fair price show from me and tagged with the organization. And I made several representations to the authorities, particularly to the deputy commissioner who was the in charge of the distribution of the PDS articles, highlighting those issues that the organization which is being allotted the PDS articles is not entitled because this organization.
Who's for respondent number 5?
Lordship, this honorable court strike out the name of the respondent number 5. It is reflected in the order dated 1/4/2004.
It has been struck off.
Yes, Lordship.
1/4?
1/4/2024. The court observed that as no relief has been sought against the respondent number 5, the name of the respondent number 5 is struck off.
But you said that respondent number 5, 46 numbers of your.
Yes, that was my part of the pleading. And I have annexed the all relevant documents also.
Yes.
But it is the observation of the honorable court, so I can't say anything on it, Lordship.
So what is your grievance?
The grievance is that, Lordship.
Is your grievance de-taking of 46 numbers of families from your organization and giving it to respondent number 5? Or is it the allowing certain other organizations to lift the PDF materials?
This my prayer I specifically made in the page number 11.
Page 11.
Page number 11, Lordship. To direct the respondent number 2, 3, and 4 not to allot food grains to any cooperative society organization other than the 3 notified categories: GPSS, WSS, and LMPS, These three notified categories are entitled to do business of the PDS articles. Now, Lordship may come on the page number 54.
There is no closing. Why any other cooperative society, why should not they be allowed? Why monopoly?
Register of the cooperative society, what saying, Lordship will find in the page number 54. He is telling that this cooperative society is not registered as a wholesale consumer cooperative society. And as per their bylaws, they are not entitled to do business with the PDS article. Yes, they are permitted transportation. They can transport the PDS articles from the FCI go down to the fair price show.
No, are you submitting that other than your client, there is no other organization having license for wholesale?
Within the jurisdiction of Golpara town.
Yes, there is no
There
other.
is no other organization.
So
Even
what
though
is-
not are registered as a wholesale consumer.
Yes,
cooperative
registered.
society.
Yes, what do you say?
My lord, Dean April.
Ask him to come. He's
He's in leaks in court number 1. He'll come, my lord. He'll definitely appear.
no, he's objecting. Otherwise, we'd have given
No,
another.
no, normally I should not raise objection. That is I understand, but it's for the fourth consecutive time.
Court number 1.
So only one question. In the district of Gwalpara, apart from the petitioner organization, is there any other organization who has the license to deal with PDS articles on a wholesale basis? If there are no, then you may have a case. If there are, what about the response number 5? It is not a wholesale license.
It is, Lordship may peruse the page number 54 of my petition. It is a part-
54.
Yes.
Yes.
I may be allowed to read it, Lordship.
Yes,
The
yes.
little background of this communication is this: when I made
The
representation
fair
to the
price
deputy
dealer,
commissioner,
carriage and contract is not registered wholesale. Where is your antecedents? Where is your documents
my documents,
that you are a wholesale cooperative society?
it is, rather I am relying on the affidavit filed by the respondent
Now
authority.
you have to have some documents.
Yes, yes, yes.
Initial documents.
Yes, Lordship will send my wholesale license, page number 13,
1-3.
1-3.
Okay.
And Lordship may peruse the page number 60 also. It is also the assistant registrar of the consumer cooperative societies confirmed that they are not entitled to do business with the PDS article.
60.
60, Lordship.
Is 2016.
Yes, Lordship. At that time,
But is the position still existing?
still it is there in the 131, page number 131 of the affidavit filed by the deputy commissioner.
131.
Yes, it is more details clarification is given there. It's a part of their document affidavit.
131 is not.
Last page of the last affidavit. Lordship.
Okay, 137. 23rd February, 23rd April,
Uh,
23-4.
yes, Lordship. It is recently filed.
Please read. Not a document. The document is of 23-4.
I am reading out, Lordship.
See the date.
23rd April
Yes,
2025.
23-4. Okay, what is there?
With due respect, I have the honor to state that the following facts in view of the reference letter as stated below. Both Fair Price Dealer Carriage and Contract Cooperative Society Limited and Gwalpara Wholesale Consumer Cooperative Societies Limited are registered cooperative societies. That is true. The both are the registered cooperative societies. The Fair Price Dealer Carriage and Contract Cooperative Society is registered by registration number so and so, it is 2016. The main objective of the Fair Price Dealer Carriage and Contract Cooperative Society Limited is to distribute essential commodities, etc. among the fair price shops under Gwalpara municipality area. Distribute, that is, they are entitled for transportation.
Yes.
Further, it does not include, Lordship, this is
Yes,
important.
we have read.
It does not include to do business PDS commodities as per the clause of their bylaws. The copy of the bylaws is enclosed here with an extra 1. Registered of the cooperative society is saying that they are not entitled to do business of the PDS article. Now it is my organization. The Gwalpara Wholesale Consumer Cooperative Society Limited is registered by registration number so and so. The main objective of the Gwalpara Wholesale Consumer Cooperative Society Limited is to arrange for bulk purchase of consumer goods, articles, and other necessaries, and to sell the same to each member of the reasonable price, at the reasonable price. Manufactured goods and articles either by itself or in collaboration with its members, to encourage self-help, thrift, and cooperation among the members, and to enable its members to deposit their
We have read this. Yes, we'll have it after some time. Let Mr. Nath come. Please call him.
He's still in leaks now.
One thing, Lordship, my last submission is that.
Let him come. Let him.
Yes, sir. Yes, sir. Yes. Yes.
Item 4. Yes.
Okay, sir. My lord, if I may take your lordship to page 46. Hello?
Yes. What is the subject matter?
The subject matter, my lord, my bank account, I'm an MSME business, but my bank account was turned NPA due to non-payment of dues, which I'm not disputing, my lord, but there's a law laid down by the Honorable Apex Court based on a notification of 2015, which says that if an MSME's bank account is classified as NPA, before that, a process needs to be followed, my lord. And my contention is that that process is not followed, my lord. And if my lord goes to page 46, that is the notification. Title Framework for Revival and Rehabilitation of Micro, Small and Medium Enterprises. Here, if my lord looks at point 1, it says identification of incipient stress. Identification by banks or creditors before a loan account of
You said that the procedure laid down has not been followed.
Yes,
by the bank
my lord.
before declaring an MSME, that
Yes.
is the petitioner, as an NPA. Yes, Mr. Sharma, you are for the bank.
I'm for the bank.
Have you followed the procedure?
Yes, my lord, so far the notification 29/5/2015, 46 page number, that has been actually corrected and amended on 17/3/2016, my lord. Page number 59, my lord, in his petition itself.
Yes.
In that petition, my lord, in page number 59, there is a page number 59, my lord. This notification, my lord, in page number 59, para number 1 here, in order to provide the simpler and the faster mechanism to address the stress in account of MSME and to felicitate the promotion and the development of the MSME, the Ministry of such and such, such and such.
Yes.
While their gazetted notification dated May 29, 2015, his notification had notified framework of revival and rehabilitation of micro, small and medium enterprises. However, certain changes in the captions framework have been carried out in consultation with the Government of India Ministry of MSME in order to make it compatible with the existing regulatory guidelines on income and such and such, such and such. Now, my lord, in page number 61, my lord,
Yes.
what he is reading and after, my lord, the identification by the bankers and credit, there is a two type of identification system. First by the bank and second by the entrepreneurs themselves.
Yes.
Now, the second, on the basis of the above early warning signal, second line, the branch maintaining the account should consider the forwarding the stress account with aggregate loan limit above 10 lakhs to the committee as referred in the para number 3. Now, his loan amount is 8 lakhs. He wants to refer this to the committee. But as per the notification, above 10 lakhs can be go to the committee and below 10 lakhs can be by the branch manager itself. And what is that notification, my lord? So far, the special mention account is concerned, that is only for the bank. What bank do? Normally, before NPA, bank mark, as per the system, they mark SMA 1, SMA 0, SMA 1, SMA 2. In SMA 1,
What is SMA?
Special mention account.
Okay.
So that is for the purpose if some MSME is there, if SMA 0, then the branch manager itself try to see if there is any provision of rehabilitation or reconstruction or all. In SMA 1, that they will send to the committee. If it is more than 10 lakhs. If it is not more than 10 lakhs, they will not go into service.
Here the account was less than 10 lakhs.
8 lakhs.
8 lakhs.
8 lakhs. He is referring 2015, I am referring 2016. In fact, my lord.
Yes, what do you say,
Yes.
Mr. Watakur?
Point 2.2, my lord, of the same page. The
Yes.
answer is there. As regards account aggregate loan limits up to 10 lakhs. So within 10 lakhs, identified as SME 2, the account should be mandatorily examined for CAP by the branch itself under the authority of the branch manager / such other officer as decided by the banks in terms of their board approved policies. Other terms and conditions such as time limits procedure to be followed as applicable to the cases referred to the committee as referred in para 3.3 should be followed by the branch manager designated official. This is important, my lord. However, the cases where the branch manager / designated officer has decided the option of recovery, which is in my case, has decided the option of recovery under CAPA instead of rectification or restructuring, which I am seeking, my lord, as mentioned in para 5.3 A or B, should be referred to the committee for their concurrence, my lord. This was not done. And this is the whole case, my lord.
No, my lord.
Okay. You say that still he has the option to go for a recovery, but that has to be concurred by a committee, which has not been done. And this is for loans up to the aggregate of 10 lakhs. So you come within this less than 10 lakhs, you can still go for a recovery. You also need to have a special, what is that, mandatory examination for the corrective action plan.
Yes.
That apart, whether it is done or not, if you go for a recovery, you get it ratified by a committee. You have not done. That is your case. Yes, you have you done that?
Well, then again, the point number 2.3.
Yes.
Identification by the borrower enterprises. Any MSME borrower may voluntarily initiate proceeding under this framework if the enterprises reasonably apprehended failure of its business or its likely inability to pay the debt, or there is.
Will this be applicable? Did they on their own?
My lord, I'm coming to that, my lord. First of all, we have to understand, my lord, in this case, the loan has been sanctioned in 2022. for the establishment of one music studio.
Okay.
Then, my lord, immediately it started no payment. EMI stopped in 2022 itself.
Hmm.
In 2022 itself, we have given 90 days time to the borrower to
Okay.
pay the amount.
Okay.
That is first SMA 1, SMA 0, 30 days, SMA 1, 30 to 60 days, then
SMA 2, 90.
SMA 2. Then we declare NPA.
Oh.
Now, my lord, kindly see, they have, as per them, in page number 22,
22. Yes.
NPA, the accounts become NPA on February 2023, madam. That is very important, madam. In page number 22, they approach the deputy commissioner.
Yes.
The reason why they are not paid the EMI.
Hmm.
In this, in para number 2, that said due to artificial flood in the city, Guwahati, on 6-7 October 2020, it is much after the NPA. Well, they have
NPA was declared when?
February 2023. Flood in October 2023. They have never communicated to the bank. Reason why they are not able to pay the amount. Well, in this way, for the MSME, everyone comes under the MSME if it is 25.
No, but have you got it concurred by the committee?
I'm not aware. I have to take instruction on that.
That is the point.
That I will
On
take
facts,
instruction.
you may have a case, he may have another case.
Yes.
But the procedure requires that you may go for recovery, but you get it approved, got it approved by a committee. That instruction in place before us. We will not go into those, whether flood was there or this, every person will have some difficulty.
Yes, madam.
That in that case, all the loans will become bad. You will not be able to recover. If I may have another cause, I may have something in my family, somebody has died, somebody has become ill. So, but the thing is that the recovery, there is a procedure prescribed so far as MSME is concerned regarding the concurrence. You have with the concurrence. Why is your read becoming infractuous?
Because, my lord, there's a pending civil court proceeding going on, my lord. There I
Regarding
have submitted my WS, but
for
if the recovery
civil court for against what?
against the notice of recovery, my claim
For recovery of that amount, because, my lord, since they have not paid, my lord, in a Supreme Court cases, there is a surfacing matter. But in our case, since it's below 8 lakhs, we have approached the civil court for the recovery of the matter. And there is a lots of time because now it is a stage of the WS, they have filed last notice. So they don't have any urgency in that matter.
Okay. And then what is the cause of action? Then if your recovery, you have gone for recovery.
No, no, I have gone for that.
Oh, you have filed a money suit.
Yes,
Okay.
it's a simple money suit.
Can't you show your cause in the civil court? If it is a thing which is
But,
barred by
because
law,
it
why
involves
do
a-
you not need to come to the writ court? It has
Yes,
proceeding.
Because in NPA, they can plea before the civil court that NPA is wrongly done. Taken down.
Because, my lord, it involves an interpretation of law, my lord, and a positive
That
direction.
that cannot be done by a civil court.
And a positive direction to the bank to follow this process. my
Civil
lord.
court
And
is civil court is not competent.
yes, my lord, that equitable jurisdiction, my lord, this.
Why not?
Because. my
Which
lord,
court does not exercise equitable jurisdiction? The
But-
equity is everywhere.
And point of law is also there, my lord. So
Point of view, everything can be decided by a civil court. Is there any incompetency or lack of jurisdiction? This point is a very valid point. In fact, you'll have much better access and scope to establish your point.
And my lord, there is a very recent Supreme Court judgment also, which remanded the matter back to high courts. Because first they thought that this was not mandatory. So,
No, on the point of law, we are not saying anything. You have shown a part that which requires concurrence
Yes.
by the committee. This point you can very well raise in the written statement, which probably you have done.
yes, we have.
And you may also raise a preliminary issue, preliminary objection, which can be gone into by the court as a preliminary issue.
But and my
Yes, sir,
lord,
you take instruction on this.
Similar.
Uh, oh, heard Sri I. Borthakur, learned counsel for the two petitioners or what?
One one is the MSME, the other one is the proprietor. My lord.
Petitioners. Also heard Sri B. Sharma, learned counsel for the bank.
For the bank.
In support of his contention towards maintaining the present challenge, the learned counsel for the petitioner has submitted that before initiating the action for recovery, the branch manager is required to take the concurrence of a committee which is envisaged in the, where was it?
A notification, 46, my lord.
In the notification dated 29/5/2015.
Ministry of MSME. My lord.
What's the, the learned counsel for the bank has, however, submitted that the said notification has been that after the said notification, another notification dated 17 March 2016 has been issued, which is holding the field para. Perusal of the both the perusal of the notifications, including the subsequent notification, will, however, reveal that, where is it?
This is page number,
51, my lord.
page number 61.
Reveals that there is a requirement for
At the end, my lord. Last sentence.
referring the matter by the branch manager / designated official to a committee for their concurrence. Full stop. Sri Sharma, the learned counsel for the bank, prays for some time to obtain specific instructions in this regard. Para. List when? After 2 weeks?
2 weeks.
We give a date?
Date as well.
List on 19th.
Obliged.
Okay. I'm sorry, but I got stuck.
Yes.
I'm sorry, but
No, doesn't matter. He's saying that it has to be restricted to a wholesale license holder, which in the district of Gwalpara, the petitioner claims to be the lone wholesale license holder. And the other one, respondent number 5, whose name, however, has been struck off, he is not a wholesale license holder. He is a carrier. So what is your response?
in fact, we have filed the affidavit to that effect, and we denied. We denied
But the documents which are on record, including documents from the district commissioner, who show that apart from him there is no other.
No, my lord, the clarification has been received from Assistant Registrar of Cooperative Societies.
Yes.
Because he has placed one letter of 2016.
Yes.
And to that effect, a clarification has been given.
Page.
My other points I will take to straightway kindly come to 138, my lord, page 138.
138. May not be 138.
Yes, my lord.
May not be 138, maybe 137. Oh, it doesn't matter. We'll take.
Annexure 12, my lord.
12, yes,
Roman
correct.
12.
Yes, we have read that 23rd of April.
23rd of April.
Yes,
25.
please read.
Yes. With due respect, I have the honor to state the following views in reference to letter as stated below. Both Fair Price Shop Dealer Carriers and Contract Cooperative Society Limited and Golpara Wholesale Consumer Cooperative Society Limited are registered cooperative
See,
society.
the second one is the petitioner, isn't it?
Second one is the
First is the respondent number 5, struck
Five.
off.
Yes.
And then
The fair price dealer carries and contract cooperative society limited is registered by registration number so and so of 2016. The main objective of the fair price dealer carries contract cooperative society is to distribute essential commodities, etc. among fair price shops under Goalpara municipality area. Further, it doesn't include to do business of PDS commodities as per clause of their byline. The copy
Yes.
of the byline is so and so, so and so. So the fair price dealers carries and contract cooperative society. This is also a registered cooperative society, my lord. It was
Yes.
registered in 2016.
Yes,
And we have taken that stand in the affidavit in opposition.
yes,
We have already indicated. So the Goalpara Wholesale Consumer Cooperative Society Limited is registered registration number so and so dated 13/12/1965. The main objective of the Goalpara Wholesale Consumer Cooperative Society Limited is to arrange for bulk purchase and consumer goods articles so and so, and to sell the same to each member of the at a reasonable price to manufacture goods and so and so. But we are concerned here with the lifting, my lord.
Lifting is not my issue, Lordship. I am neither
We
agreeing
come to
because
the
of the
prayer,
lifting
come to
and
the prayer of this repetition.
Yes, my lord. I'm taking your lordship to the prayer. He has alleged, page 10,
Yes,
to direct the officials respondents to follow and execute the SOP dated 6th of December 2023 for allocating, lifting, transportation of commodities under NFSA 2013. Secondly, to direct the respondent number 2, 3, and 4 not to allot food grains to any cooperative society organization other than the 3 notified category of GPSS, WCSS, and LAMPS as per provision of SOP, and to direct the respondent number 3 to 4 to restore the fair price shops. That is the second prayer. We have also responded to both the grievances. Number 1, my lord, kindly take up our affidavit in opposition. And before that, kindly allow me to read 2-3 paragraphs of his petition because that is his case. Para 4, 5, and 6
of the repetition.
of the writ petition. Page 5. His case is, the petitioner states that as per the SOP, only 3 categories of license holders are entitled to lift food grains from FCI. The nominees of GPSS, WCCS, LA, MPS are to lift the allocated food grains from FSD to FSD of FCI,
With the help.
with the help of the designated transporters against the release order issued by the FCI. The petitioner states that clause 3 of the SOP says district authority shall engage transporters through e-tendering in every financial year. Transportation is to be carried out in 2 tier 1 from so and so to tier 2 from so and so. Then 6, petitioner states that the petitioner organization is a only WCCS in Goalpara town, wholesale consumer cooperative society in Goalpara town having a wholesale license. Therefore, as per SOP within Goalpara town, only the petitioner organization shall be allowed to lift food grains from FCI with the help of the designated transporters. So this is his case, as regard the first grievance. Then kindly come to our affidavit, my lord. Second grievance he has narrated in paragraph number 7, and ultimately in paragraph 11 he has summarized both the grievances.
Yes.
Petitioner states that prior to 2016, 87 number of fair price shops retailers were attached with the Goalpara Wholesale Cooperative Society. In the year 2016, another cooperative society was registered in the name of Fair Price Dealer Carriers and Contractors Cooperative Society. This is the private respondent. Subsequently, the said cooperative society has applied for sub-wholesale license under so and so. Accordingly, license was issued. Now he says, my lord, the petitioner states that when the new society came into existence, 67 number of FPS taken away from the petitioner organization and tagged with the sub-wholesaler. It is pertinent to be mentioned that 67 number of fair price shops were taken away from the petitioner organization without assigning any reason and without hearing the petitioner. Then his grievance is kindly come to para 11.
That is also a sub-wholesaler, the respondent file.
According to him,
Yes.
this is his case, according to him. And he has also produced a letter before the Honorable Court that, and to that letter, we have sought the clarification. The Assistant Registrar of Cooperative Society he has clarified that we have annexed in our affidavit. That is page 138 in our affidavit. That I have read, my lord. So after the all the statements, my lord, these are his main grievances, my lord, in paragraph 11. Number 1, petitioner organization is the only wholesale consumer cooperative society in the Goalpara town. Therefore, as per SOP, the petitioner is entitled to lift food grains from FCI to fair price shops located within Goalpara town. But in violation of the SOP, the respondent authority allotted food grains, articles, and permitting the private respondent to lift from FCI. The private respondent is not entitled to lift food grains from FCI because the said organization is registered under name and style of fair price dealer carries and contract cooperative society, which may be entitled for transportation of articles from FCI. The second is
The private respondent, it should be, private respondent is not entitled to lift food grains from FCI because the said organization registered under the name and styles dealer carriage.
or he said because their name is dealer carries and contract cooperative society.
Name will not be anything.
That is
All the name.
that is why he's referring.
Name, how
second,
will the name may make any difference?
Lordship, name is not at all issue. AIB, CPT, name anything may be, but the issue is that what the authority is telling. Lordship, one thing is that whatever my friend has submitted, lifting, allotment, transportation, 3 things. What the SOP says, lifting with the help of the designated transporter. This is all right. That is, the allotment shall be made to the wholesale consumer cooperative societies.
Yes.
And it shall be lifted with the help of the designated transporter.
Yes.
And here the organization, the private
Now,
organization.
what is your grievance? That the private respondent 5 has been given one job, which they are not authorized to do. Which is
They are authorized for transportation.
Yes.
That is true. I have categorically
Then
stated.
your grievance is confined to what?
They are allotting food grains to the private organization. They are doing business of the food grains or PDS articles, which is not permitted.
Now, transportation and what distribution, how will it be different?
Yes, Lordship. This is the important issue. That first, that the organization, a wholesale consumer cooperative society, she may be allotted 100 tons of food grains. That shall be kept in the FCI godown. And with the help of certain transporter, that shall be transported to the fair price shop. This is the rule of the transporter. But here the food grain is being allotted in the name of the consumer cooperative societies and being transported by the transporter. My case is that the organization, I'm agreed because of which that they are the transporter. I am telling nothing about it. They are entitled for transportation.
Yes.
Transportation is not my job.
Yes.
But the fair price shops are being tagged with them. They are allowed to purchase the food grains from the FCI, and the documents which have referred my learned friend, which candidly says that they are entitled for distribution. They are not entitled to purchase the food grains from the FCI. But transportation is one thing. In violation, that is why in my petition I have stated that in violation of the rule, guidelines, and the SOP, the food grains are being allotted to an organization which is entitled for transportation, which is not entitled to do business of the PDS articles. And they are no fair price shop supposed to be tagged with them. And they have admittedly, which is disclosed in the page number 131 of their affidavit, which says that my organization is entitled to arrange for bulk purchase of consumer goods articles and necessaries to sell the same to each member of the reasonable price. But this clause is not applicable in the case of the private party. That is, they are not entitled to purchase the food grains from the FCI. They are entitled for the transportation. Yes, transportation they can do. I am not at all agreed.
But cooperative society registered, is a cooperative society constituted only for transporting goods from the FCI to the, they are also sub-wholesaler.
Some lordship.
Aren't they sub-wholesalers?
Let us examine the section 9.
Is a sub-wholesaler. You have just read it out.
In the public distribution system, this system alone, there is no concept of purchase of this rice from NFSA rice from the FCI godown. Rice is allotted by the government. They don't have to purchase. Three works are there, my lord. One is lifting, other is transportation, and the next is distribution. Lifting will be done as per the SOP he has annexed, my lord, at page 16. Lifting of allocated food grains is to be done in the name of the GPSS, WCS, or LAMPS. Then for distribution, for transportation, transport contractors are there. Transportation job has been given to different. He has no grievance to that. Then distribution, ultimately it will be distributed to the fair price shop through the fair price shops. It will be given to the beneficiaries. So
Now, he is a cooperative society who has a wholesale license.
he says that he is the only person to lift the goods, not the private respondent.
I am not selling, it is selling by the registrar of the cooperative societies. Lordship, when a society is formed, it should it should have a bylaws, and bylaws permit the organization what to do and what not to do. And on the bylaws, the registration is given. That is true. The section 9 of the Cooperative Societies Act 2007, but if I may be allowed to read out this section 9.
Cooperative society. Yes.
A cooperative society shall frame their own bylaws, and affairs of the cooperative society shall be managed in accordance with the terms and conditions and procedure.
You're reading which?
Section 9.
9.
Lordship, I may start.
Yes, please.
A cooperative society shall be framed their own bylaws, and affairs of the cooperative societies shall be managed in accordance with the terms and conditions and procedures specified in the bylaws, subject to the provisions of the Act, and functioning of the FB cooperative society shall be regulated by its bylaws. The bylaws may contain such as matters as decided by the General Assembly and shall be specific and confined only to the matters provided in Schedule B. However, the bylaws of the society shall in no case suppress the provision of the Act.
Supersede. Not
So
suppress,
their
supersede.
action and inaction shall be regulated by the bylaws, and the bylaws has to be submitted to the assistant registrar of the cooperative societies, and as per the bylaws, registration is allowed. But here, section 9 says that entire action shall be guided by the bylaws. The registrar of the assistant registrar of the cooperative says their bylaws does not permit to do business with the PDS articles. That is, the registration is not in accordance. That is, the registration certificate does not permit them to carry out the business of the PDS articles.
Yes.
This is the requirement of the law, and which has been followed by the assistant registrar of the cooperative societies. But in violation of the bylaws, in violation of the provision of the registration, the PDS articles are allotted to them. Fair price shop are tagged with them. They are allowed to do business with the PDS articles. That is why I am acting. And which has been repeatedly since 2016, when I first made the presentation, the Deputy Commissioner forwarded the same to the.
Sir, not you need to be very specific. What are the functions of the Responder 5? What are they doing? Are they, is there any overlapping of their function which is not permitted and which transgresses into his operation?
Well, the clarification given by the ARCS, if I am permitted to take your lordship once more.
Yes, 138.
Once more.
Yes, yes, please.
138.
I've seen that. That is what.
Lordship. The function, as he has indicated from the bylaw, the main objective of the fair price.
Mr. Nath, he is not, he is rather endorsing this.
Yes.
The separation of what are the specific functions, and he is saying that still there have been violation. That is his case.
Violation of the SOP.
SOP as well as the.
That is the part of my affidavit, Lordship, page number.
No, what do you want to show in 138?
Yes, yes. Well, arranging bulk purchase of consumer in respect of petitioner, my lord.
Yes.
The Golpara Wholesale Consumer Cooperative Society is registered so and the society is to arrange for bulk purchase of consumer goods articles. My lord, this has nothing to do with this PDS system. This has nothing to do. How the petitioner cannot be, my lord, petitioner cannot read this bulk purchase thing with the PDS with this PDS network, my lord. Here he is not required to buy. That is what, my lord, I'm submitting, my lord. And the second is, my lord, our affidavit, we have, my lord, kindly come to our affidavit, my lord. We have said that both are registered societies, and both of them are eligible for the work as per the SOP. Therefore, there is no violation of the SOP.
Lordship, SOP.
Where is the question of bulk purchase for this?
Then, Lordship,
Under NFSA rights.
This is the basic conception of that of the wholesale consumer cooperative societies. It is a, Lordship, then from the FCI, every consumer cooperative societies, from where they purchase the product? Only from the FCI. They do not purchase from any private party. What the my learned friend is submitting, if
NFSA rights is not.
NFSA is providing some certain guidelines, that is true. But the wholesale consumer cooperative society is purchasing food grains from the FCI, and they are getting 13% commission on 3% commission on that. That is why it is called business. They are not going to purchase from a private party. And more particularly, Lordship, this is clear evidence that this organization is
What
not
is the meaning
registered.
of this, Mr. Nath?
My lord.
The first one, second paragraph at 138.
Yes, my lord.
So far as the fair price,
Fair
the
price.
respondent 5 is concerned, one is okay. It was registered in the year 2016. Thereafter,
The main objective of the fair price dealer carries and contract cooperative
is to
society
distribute.
is to distribute essential commodities, etc., among fair price shops under Golpara municipality area. It does not include to do business of PDS commodities as per clause of their bylaw.
Now, what is this meaning? If you are allowed to distribute essential commodities amongst the fair price shop in Gwalpara, then what does it mean that it doesn't include to do business PDS commodities as per clause of their bylaw? What is the meaning?
But
Can I submit, Lordship?
Just a minute, we will come to you.
But so far the stand of our stand is concerned, my lord. We have taken a stand in the affidavit that there are two wholesale license holders in the Golpara district, and one is petitioner, other is the private respondent. So there is no bar as per the SOP, so we have not violated the SOP.
But no, what is the meaning then? This clarification given by the Western Register of Cooperative Societies, Gwalpara, that it does not include to do business PDS commodities as per clause of their bylaws. So what is the differentiate? How do you differentiate between the essential commodities and PDS commodities? Do you have this annexure 1 to the in fact their bylaws?
No, my lord, this we have only received this, my lord, the letter, the enclosure which has been provided, my lord.
No, it is not impossible that there may be some bylaws might have said something that you cannot do business, means you cannot sell or something. PDS are only for distribution. Maybe that is the meaning. We do not know.
My lord, what I am trying to submit before your lordship is that the case of the petitioner is that I am the only wholesale cooperative society. We have said
That is it, yes.
That is his case, and we
Yes.
have said that no, there are two wholesale cooperative societies in Gwalpara, and the register of cooperative societies said that in 2016 the private respondent number 5 has been registered. They have a registered license. They are a registered cooperative society. So to that extent, my lord, that is what our stand is. Therefore, we said that the wholesale cooperative societies and the fair price so and so are both cooperative societies and both of them have equal rights and privileges. That is our stand in paragraph number 6. That is our case.
I'll rely on the page number 54. This is not registered
I
as a, this is the.
don't know the bylaw, the detailed
No,
bylaw.
no, Lordship,
that-
this is,
that I
let
have-
us,
that I have no-
let us forget about the bylaws. They are the assistant registrar of the cooperative society is the authority to analyze the bylaws, is the authority to register the cooperative societies, is the authority to clarify it falls under which category.
Yes, then what is the meaning of the main objective of response number 5 is to distribute essential commodities amongst fair price shops.
Distribute, that is the, yes, it is my understanding.
Amongst fair price shops, not to distribute, not to the beneficiaries. It will distribute, then it will have the power.
It
How
will
is it
have the
affected?
power to distribute,
Yes.
yes, distribute, but not to purchase the PDS articles from the SCI. Lordship, this is, I'm coming, the allotment.
Is there an aspect of purchasing?
Purchasing, that is, when the allotment is made.
You don't
Allotment,
purchase, does the distributor purchase?
Lordship.
PDS items.
Lordship, the allotment is given by the authority that FCI, that 100 crores is allotted to that wholesale consumer cooperative societies. Thereafter, this 100 tons are being transported and distributed by the transporter. Now, it is being lifted by the wholesale consumer cooperative societies with the help of the designated transporter. And this transporter is empowered to distribute these articles to the fair price show.
Transporters may be it may be hired,
Allotment,
hired by the cooperative society, but it's cooperative society which has been entrusted, response number 5, or given the powers to
distribute
among fair price shops in Gwalpara.
That is my understanding is that, and Lordship, this page number, this communication of 2025, it has to be read with the essence of the page number 54 and page number 60 of my petition. It is a continuous process. The authority is same.
54
and 60.
What is 54?
54, there is a little background of this communication is that.
Which subject? I have to inform you that fair price is not registered as wholesale consumers cooperative society. Yes, yes, Mr. Nath, immediately we'll have your like to have your response to 54, page 54. First paragraph, second line.
Well, this was brought thereafter. The Honorable Court has directed us to take the clarification, and that is why that second clarification was taken. And it was annexed, my lord. Court order के डाउन है।
You have brought this in way of your reply affidavit.
Yes, sir.
Reply affidavit. Have you responded to this?
Yes, yes.
What is your averment, Mr. Azudar? Submits that a fair price general contract is not a wholesale seven.
Page number 52, Lordship.
You have not even verified your pleadings. You have not verified your pleadings. There is no verification. How could you file without verification? You have not verified the pleadings. Paragraph 9 is the verification paragraph.
But I'm coming.
But nonetheless, is there any response to this document? Subsequent document. This document is of 2020.
Yes, my lord. In the additional affidavit at paragraph 4,
Page,
page 67, we have clarified, my lord.
67,
Page 67, para 4.
yes.
We have clarified to the extent that in a communication dated 27/10/2016 issued by the ARCS Goalpara, it is clarified that the Fair Price Dealers Contract and Carriage Cooperative Society Limited was formally registered on 31/8/2016, and the said cooperative society was subsequently granted PDS license by order number so and so dated 15/9/2016. According to further correspondence received from ARCS Goalpara dated 23/4/2025, the main objective of the Fair Price Dealers Contract and Carriage Cooperative Society Limited is to
Somehow we have not dealt with this letter of December 2020,
Lord,
21st of December.
this was an information given to him, and considering that,
No, it is a letter issued by the Eastern Registered Cooperative Society to the department, to
Yes.
the deputy director.
Yes, my lord. So therefore, from the department, they have sought a clarification from the Assistant Registrar of Cooperative Societies whether they are registered or not. Because this letter said that I have, if Lordship is holding page 54, this says that I have to inform you that the Fair Price Dealers, Carriage and Contracts Cooperative Society Limited is not registered at Wholesale Consumer Cooperative Society. And secondly, as far
as diversion
as
of agents,
so for diversion of agents from Goalpara Wholesale Cooperative Society Limited and engagement of Fair Price Dealers Contract and Carriage Cooperative Society in the PDS business is concerned, this office has no comment to offer, as it is a matter of Food and Civil Supplies so and so department.
see, the main heartburning of the petitioner is regarding 67 numbers of consumers who
Yeah.
have been shifted from him to
Yes.
the response number 5.
Lordship.
That is the main purpose.
That is the main
Here,
purpose.
this letter has left that unaddressed.
No,
So no comments.
we have responded to that, my lord, in the affidavit. Because that is the second issue. We are now on first issue, and that is the second issue. If Lordship kindly comes to our affidavit, my lord.
Yes, page.
Page number, para 7, page 34. Many of the fair price shops, they have resigned because now we have streamlined the situation, the thing, my lord. I'll refer to a document to paragraph 7.
Paragraph 34.
Page 34, para 7. It is stated that in the year 2016, prior to Fair Price Shop Dealers so-and-so, the response number 5 came into existence by registration number 31/8/2016. Petitioner had 87 number of Fair Price shops, but to avoid lapses of allotment of rights under NFSA 2013, for greater interest of the consumer under Goalpara municipal area, was allowed to be lifted by the order dated so-and-so by the following nominees. We have given two nominees. One Iftihar Uddin, Fair Price Shop Dealer, Ward number 10, and second is Aminul Hussain, Fair Price Shop Dealer of Ward number 7. After Fair Price Shop, that response number 5 came into existence.
No, Mr. Nath,
Lordship.
once we are in this page,
Lordship.
paragraph 6 says that in Goalpara town, there are 2 wholesale license holders.
Yes, sir.
It's a clear statement.
Yes.
And if you match this compared with it, page 54,
Lordship.
how do you reconcile? Have you said that 54 the situation was different, 2020 the situation was different, and thereafter this affidavit has been filed recently? This is the position. 54 says that there is no registered wholesale consumer shop other than the.
We filed the affidavit, then he responded with this 54, page number 54. He has filed the affidavit in reply to our affidavit. Then we have sought a clarification, and the page 138 came. In page 138, they said both Fair Price Shop and so and wholesale consumer cooperative society Goalpara are registered cooperative societies.
There is no doubt about it. Both are registered as cooperative societies. I am not on that. My question is that the private organization is not registered as a wholesale consumer cooperative societies. Yes, cooperative society is all right.
And they said that they are entitled to deal essential commodities, etc. among Fair Price shops under Goalpara area. So that was the clarification we have sought and he has clarified, because at one point of time at page 54, he said that fair price shop dealer is not not registered. That has been clarified subsequently at page 138. Now, as regard the 67 fair price shop licenses, those were attached to the
Lordship,
record number 5.
One more thing, Lordship, that basically, what are the criterias to tag a fair price shop with a cooperative societies? First issue, it has to be the consumer wholesale cooperative societies. And what are the criterias? The allotment of the PDS articles. Their affidavit remains silent. This is my prime grievance, that the fair price shop are taken away from me, tagged with a private party which is not registered as a wholesale consumer cooperative societies. So my submission is that criteria is that an organization has.
Mr. Nath,
Malon.
we'll try to resolve this matter. You get this copy of the bylaw,
Malon.
which is mentioned in
India Annexure.
138, Annexure 12,
Lordship.
because this will clarify. We want to know the meaning of the second sentence.
Second sentence. Lordship.
Further, it doesn't include to do business of PDS commodities as per the clause of their bylaws. Let us see the bylaws.
Malon.
Because he is harping around that, harping that he has no grievance in principle with page 138. What his grievance is that his client is a wholesale license holder and there appears to be transgression in his business, and response number 5 is doing the business of and 67 numbers of consumers have also been detagged.
Malon.
You get this.
In fact, in our affidavit, we have said, in this particular para, we have said that some have resigned from his, because now my lord, tender has been annexed here.
Yes.
Lordship will see tier 1 and tier 2. The distance from, there are two, tier 1 is from FCI Godown to the wholesale
Right.
wholesale cooperative society. From then wholesale cooperative society to the fair price shop. And the distances are given. If the distance is
These
more,
are all relevant factors. We may not interfere with this because you know the best interest of the consumers.
yes, they're taking into consideration the distance and all these things. Some have resigned. Some fair
No,
price shop have resigned.
Everyone may resign. I'm not on that. I am on that point that Lordship, my submission is very candid and clear that the criteria which is designed by the authority.
Okay, you get this, Mr. Bharat.
I'll go.
Heard 3, Mazumdar, learned counsel for the petitioner. Also heard 3 Deenath, learned senior advocate Assam. First of para. In the rejoinder affidavit filed by the petitioner, a communication dated 21/12/2020 has been issued by the Eastern Registrar of Cooperative Societies, Gwalpara, has been annexed, as per which, fair price dealer carriage and contract cooperative society limited, put up capital, is not registered as wholesale consumers cooperative societies. Full stop. Para. To respond to the aforesaid stand, an additional affidavit has been filed by the district commissioner, Gwalpara, on 30/5/2025, along with which a recent communication of 23/4/2025 has been enclosed. Full stop. The said enclosure refer to the bylaw of the aforesaid cooperative society as which, however, has not been enclosed to the additional affidavit filed. Para. Srinath, the Learned State Council, submits that copy of the same would have relevance in this matter and in clarifying the dispute. Full stop. Para. He accordingly prays for and is granted 2 weeks' time to obtain a copy of the same. Full stop. List after 2 weeks.
Lordship, can I pray for a date?
As prayed for list on, yes, suggested it.
Twenty,
2022.
26th of law, 26th.
Yes, 26th.
Lordship.
Lordship.
Please, no, he will leave. Meeting is there. Right, no, he will leave. Meeting is. Yes. 16.
Yes, sir.
Yes, please.
And please, your lordship, my lord. This is.
There is a caveat.
My lord, I think. I'm not 6 and 7, this one.
Ah, see the caveat. Who is for the caveat?
6 and 7, my lord. That's one.
Huh? You appear. It's just.
Page Das is
Oh, you are
my
there.
colleague, my
Okay, okay. Okay. Yes, what is this?
My lord, the interim order is, my lord, page 48, my lord. The election was conducted in Udalli Samobhai Samiti Limited on 23/9/2023.
Election?
Election of
Who are you?
Udalli Samobhai Samiti Limited Hujai was conducted on 23/9/2023, my lord.
23/9/23.
23, my lord.
Election for Samavai Samiti.
Yes. Then the result counting process started on 25/9/23. And the counting was over in the wee hour of 26/9/23. So what had happened, my lord? The result was declared, my lord. Annexure 1 is there. Annexure 2 is there, my lord. Result is declared, page 23. In presence of all the parties, returning officer and other officials, and all of them cooperated in the election, and the result was declared. After the declaration of the result, your lordship, what had happened? In the morning of the 26th, in the wee hour, the respondent number 6 and 7 filed a representation before the authority for recounting of the ballot box.
For?
Recounting of the votes.
In the results declared, you were one of the elected candidates.
Yes, I am one of the elected candidate board of directors. Others are also board of directors. And
You distributed sweets also.
yes,
Sweets distributed.
my lord.
Sweets distributed or not?
My lord, definitely it will be distributed.
In the wee hours, you might not find sweets.
Yes.
You
my lord.
postponed. Okay, then what
Now,
happened?
what had happened thereafter, my lord? After the result was declared,
Hmm.
the complaint was filed before the
6 and 7.
yes, by the 6 and 7,
Hmm.
Annexure 3, my lord.
Hmm.
And in the complaint, recounting of votes was demanded.
Hmm.
Now, after the application was filed on 26/9/2023, they have to deposit the money recounting fees
Hmm.
before the authority, but they did not deposit the amount as per the law.
Yes.
Now, on 27/9/2023, next day,
Yes.
they have filed an application Annexure 3A before the Assistant Registrar of Cooperative
Which
Society.
day? 27/9.
Yes, 27/9
Application for?
for recounting of votes for the election of Udalli Samobhai Samiti Limited.
Another application.
Another application next day.
Oh.
Next, thereafter, what happened, my lord? The Assistant Registrar of Cooperative Society written a letter on 29 September 2029.
23.
Yes, 23, for counting the process with documentary evidence and videograph to be submitted by the complainant before the authority.
For?
For recounting what
Recounting.
happened and how it has happened with the videography. If there is any anomaly, this was written by
It means he asked for materials from the
asked for material.
complaints to substantiate their
Yes,
complaint.
substitute the allegation level against the. Now thereafter, what has happened, my lord, on 6/10/2023, Annexure 5, my lord, an appeal was filed before the Register of Cooperative Societies under Section 111 of the Cooperative Act.
By whom?
By this section, by respondent number 6 and 7.
Why?
For recounting of the votes and not to approve the election held.
Their application was already pending before the ARCS for recounting.
Yes.
Then why another application?
They have submitted, it is up to their authority to decide, my lord.
Another appeal was filed.
Another application. Now, what had happened, my lord, in the meantime, on 6th October 2023, on the same day,
Yes.
the assistant register of cooperative societies issued a letter to this respondent number 6 and 7 and others,
Yes.
stating that recounting of votes in respect of recounting of votes who did not deposit the required fees, which has to be submitted as per the law. So your application is rejected. Annexure 6, my lord, 6 October 2021, issued by the Register of Cooperative Societies.
Yes.
Thereafter, my lord, what happened? They have immediately rushed to the Honorable Guwahati High Court and filed a writ petition. Despite pending of the appeal before the Register of Cooperative Society, Honorable Guwahati High Court has passed an order directing the authority to approach the affiliate authority. The order is page 47, my lord.
What is the order?
Order is, my lord, in view of such submission made by Mr. Bora, learned counsel for the petitioner, last paragraph, this writ petition is dismissed on withdrawal with the observation that in the event of any order is passed in the appeal, which the petitioner find to be prejudicial, they would be at liberty to avail appropriate remedy as permissible under the law. The writ petition was dismissed, directing to file before the appropriate forum.
Yes.
My lord, thereafter, what has happened? The Register of Cooperative Society issued notice upon the writ petitioners. As the respondent number 6 and 7 and others filed the representation against the recounting board and not to give approval of the committee of the election, my lord. So after receiving of the notice, both the parties appeared, and the learned Register of Cooperative Societies has sought the report from the SP Hujai about any illegality or not. In the meantime, what has happened? Another date was fixed. After receiving the notice, both the parties heard by the Register of Cooperative Society. And the Register of Cooperative Society, after receiving the report from the SP, passed an order directing that since the Register of Cooperatives tried his level best to settle the dispute, come to an end, but unable, because both the parties are not agreed to recounting. My lord, both the parties are not recounting. So Register of Cooperative Society directed the authority to run the cooperative society by one-man committee and disapprove the election which was held. But because of the not approving the election, cause was not properly explained. What was the wrong committed by the board of directors? It was not mentioned. In the meantime, what happened in the order, my lord, in the last paragraph, page 49, if your lordship kindly have a look. Last paragraph, in view of the above, in consideration of all aspects, I, Sri Narayan Konwar, IAS, Register of Cooperative Societies, is of the opinion that AGM election was not held as per the Assam Cooperative Societies Act 2007. Why it was not explained. And Assam Cooperative Societies Rule 2019 is liable to be disapproved.
Election disapproved.
Under what power disapproved? What wrong has been committed? It was not discussed in the order sheet. While the General Joint Register of Cooperative Societies, Guwahati, is hereby directed to appoint one-man management to the said society to hold the AGM within 90 days from the date of issue of this order. Moreover, Hindu Mohanto, Senior Inspector Auditor of Cooperative Society, who is a returning officer, of the AGM of Udali Samobai Samiti Limited is hereby asked to show cause as to why the ballot box was not handled as per the procedure mentioned in the Assam Cooperative Society's Rule 2019. His reply should be reached to the undersigned within 7
What
days
is the
from the date.
position now?
Now, as per Sokos notice
So what
was,
is the position now?
the reply was given by the inquiry officer. As
No, we are not on that. As on today, who is running the show?
my senior inspector of the Cooperative Society is running the
Still one-man committee.
till today, my lord. Senior inspector, Mr. Vipul Kumar Sharma, senior inspector.
This
Cooperative
is going on since 23.
No, my lord, in fact, there is a interim order. So that is why, my lord. Now, my lord, in fact, in terms of the provisions of the act, if the election is disapproved, it has to be, my lord, held within 90 days. But since there is a status quo order.
Now, understood.
So, yes.
The one-man committee is running the show
One-man
because of
can-
the status quo order.
Yes, yes.
Why did that let there be election?
Yes, my lord.
You also contest.
Yes.
My lord, my lord, what now this returning officer his file his reply. My lord, in the returning officer reply, my lord, if your lordship kindly have a look, page annexure 11, page 72. My lord, operative.
See, from 2023, we are in 2025.
I respectfully agree with the lord.
August.
My lord,
Let there be fresh elections, you will contest.
My lord, if the petitioner commit any wrong on their part, they are liable to face the consequence of the law. With utmost respect, my lord. But if I am not, the petitioner did not commit
See,
any
Mr.
wrong, then why
Talukdar-
we should
See,
suffer?
Mr. Talukdar, we have not even heard Mr. Sharma.
Yeah.
He will have counter allegations that this has happened wrong, this has gone wrong. So ultimately, what will happen? These
My-
will be questions of fact.
My lord,
We have to establish, and he has to also establish. Will it be possible here?
my lord,
Let it proceed.
this fact was established by his own inquiry officer. Reply, my lord, if your lordship kindly have a look of page 74, kindly have a look, my lord.
See, you may make a submission that
My lord,
elections
page 74,
which were held on 26.
my lord, page
On
74.
26/9/2023 results declared, it was held in accordance with law, you are elected.
Yes.
Now they will say
They
that,
are also elected, my lord. Respondent number 6 and 7 also elected, my lord. They are also elected.
then why did you file complaint?
But there's irregularities.
Now, if you have been elected,
My lord, though, but there is a very huge irregularities in the total process, my lord.
no,
So
if
that-
you are elected, what is the prejudice you have suffered?
My lord, it is not based on the prejudice. But
Why not?
My lord,
Why not? Writ proceeding, mere infraction will not be enough. Show us a legal prejudice.
my lord, but my lord,
If you are elected members, why do you the process, entire process, why entire exercise? We thought that you are defeated candidates.
but my lord, my instruction is that my lord, the
No, why? Why did you file the complaint?
actually result sheet was actually signed on 25th, but result was declared on the 26th. So this
Now, after you have been
Side-
elected, what is your problem?
I understand.
That's one question you have to answer.
No, no, I-
Merely showing that this has been violated, that has been violated will not be enough.
my lord.
Court's time is precious. Registrar's time is precious.
Absolutely.
Election has been held, you have been elected. What are you gaining by one-man committee?
This is the fresh election.
You are an elected candidate. You should have been very well. You should have been on his side. Let somebody else file a complaint. Both of you are elected.
Yes, both of them are elected.
Oh,
And
What-
a result was declared on 25, my lord. It
Mr.
was
Talukdar,
only,
what was the reason of holding the
My lord-
elections were vitiated?
Yes, my lord, in fact, what has happened, allegations, counter allegations, my lord, came. They registered as an election authority, but I think your lordship.
Oh, we'll have to continue some other day.
My lord.
let it be parted, my lord, here. My lord, your lordship believable time is spent, my lord. I will be obliged, my lord. Parted.
You'll have a better chance somewhere else.
Now, my lord, your lordship will be best. Yes.
No parted business. I don't give anything for parted. Okay, we will have this, we'll try on Tuesday next.
Yes, my lord.
Tomorrow onwards, there may be some difficulty. Tuesday,
Obliged.
okay.
Obliged, my lord.
On request. list on Tuesday, no? Mr. Dutta, which matter?
Document,
Yes, we have submitted.
item number 9, my lord, only fix a date.
We'll have a date.
Okay.
Any matters where interim order is still?
Interim order is there.
Okay, look for it.
Lordship, the other item number 13.
27.
Let me fix, Lordship. Yes, I will.
Any matters where urgency is there, kindly request the court must tell give a date. Interim order, any matter, extension,
In item number 17 and 18, there is interim order.
17.